It's Friday Night Live. Thank you all for waiting. It has been a busy day. It's been a busy few weeks. I'm so glad to see you. There's literally so much on the docket tonight. No super ooper duper deep dives because we're talking about the latest on Britney Spears, the updates to the Westbrooks lawsuit with their business partner, Triller coming after Teddy Fresh for shit that's posted on Reddit. Josh Duggar had a court hearing today. Then Ron Richards had a big win in court against Erika Girardi, and the Ace family, well, really, Austin McBroom is getting sued over this YouTuber TikTokers boxing match 7 ways from Saturday. I couldn't even go with whiskey tonight because it's so much to talk about. And I forgot to make new whiskey ice cubes. And the root beer whiskey needs the ice cubes. So watermelon claw, like my basic ass is. Went with the claw. The claw. I can't wait to see where you're coming in from, what you're drinking. We have a lot to do tonight. There is so much. And I want to do questions. And we've got a few other things to talk about. So we should just get into it. Like, that's how we should start. Just like all of the lawsuits. It's like lawsuit vomit over the last few weeks. And we should just go for it. Hey there. If we haven't met yet, I'm Emily D. Baker, the badass lawyer and everyone's favorite legal commentator. I'm the host of The Emily Show, and I break down the legal shit behind the news and pop culture stories we all want to talk about. I have been a licensed attorney for over 15 years, but this is not legal advice. I should warn you, I'm a big fan of the cursey words. This channel is where the law nerds unite to talk about facts, not fuckery. Thank you for the super chat, Interstellar. I appreciate it. And you guys, a huge thank you to all of our amazing moderators who help me so much on this channel. We had a very busy stream last night, and then I jumped onto another creator's stream last night, and my DMs have blown up about that. I did not know that that video would be then made members only. No one asked me about that. I've reached out to the other creator to figure out what's going on with that because I did not know that was happening. So for anyone who was disappointed by that, I had no idea. I apologize. I have never had a creator make a stream members only after I've streamed on their channel. Those are things you normally would talk about beforehand. So I didn't know that happened. I've reached out to them. We're going to chat about it, but to the members, I saw your frustration. Thank you for reaching out to me to say, hey, this is what's going on. I appreciate you guys giving me the heads up because I did not know. I was not asked. And if I did know, I would have told you that would have been the situation. So thank you for telling me. Thank you for reaching out to me. And thank you guys for being the greatest community on the planet. I will always keep you guys in the loop with stuff like that when it's going on because I honestly just did not know. So thank you. Ario Scorpion says, considering making peach juice ice cubes for bourbon. Oh, that sounds like a great idea. That sounds like a great idea. I'm going to have to consider which it would go with because most of the whiskeys we have right now, because summer, are flavored and what would go with them. But I love that. I love that idea. I love it so much. I love seeing you guys on Friday nights. Replay crew, heart your face. Love you so much. There will be links down below. We've got a lot of topics. I'm going to do my best to remember to swoosh so that it's easy to timestamp so that you guys can see all the chapters and get to just the stories you're looking forward to. There's a poll up now, so let me know what you want to hear. We're covering some swoops first on Britney, the Westbrooks, and Triller, and then we will get into the other topics that might take a little bit longer. So Luke says, I'm drinking Korean marble soda and from Massachusetts. That sounds delightful and delicious. Delightful and delicious. Booze free, but about to partake in a special gummy Savannah. Enjoy those edibles. Enjoy those edibles. I love Vancouver Island. I love Vancouver Island so much. It's so good to see everybody. Thank you all for coming in. It's great. It's Friday. This week, you guys, can we just talk for a minute? It was the first week of school for my kids. So that's a busy week. There's still, stuff going like this with COVID and Delta variant and masks or no masks. And it's all very anxiety producing for me. I'm like, just can we just follow the decisions that are made by the people? I understand why some don't want to, but also I'm like, can we just, oh, I don't want to fight with people. So it's been a really busy week. And then getting back to drop off procedures, pickup procedures, new homework procedures. Last year was so wild to start in a new district with new schools during COVID. And so now they're going back to pre-COVID, some of the things, but we weren't here pre-COVID. So it's all new again. So last year was new. This year's new. My brain is just tired. So for everybody who's got their kiddos going back to school, it's a lot. It's a lot. Jay Thompson, thank you for the shout out and love to the mods. I appreciate it. Hello, Ottawa. Hello, Ireland. It's so good. You guys are always so supportive. It's so good to see all of you. So, y'all, we're going to do a quick Britney roundup because I think that there's still a lot of confusion. There's still a lot of confusing headlines. There's still a lot of fighting on Twitter. Jerry asked, say Britney gets a huge win in the conservatorships, and what happens to all the court filings Dad Spears did in the other states? If the conservatorship ends, then the conservatorship can't be implemented in any other state because it is over. I think that it will take some time. Hello, Bulgaria. My kid's old Taekwondo instructor. I'm getting distracted. It's just going to happen for a moment. Give me a moment. Before we moved, their Taekwondo instructor was a world champion Taekwondo athlete, Taekwondo artist, and stuntman, and had done like covers of Men's Health in Bulgaria and Dancing with the Stars Bulgaria. So I always gave him shit about it because I'm like, I love that you came to LA and that my kid gets to do Taekwondo with you because he's a fantastic martial artist. But also the moms would come to Taekwondo. There's a creator on Instagram and TikTok, Gary Brookspin, who does kind of comedy and commentary around having kids in school. And one of his jokes was a phone call with a parent who was upset because their kids didn't go out to recess. And he's like, no, nobody went out to recess today. Yes, ma'am. Well, the teachers weren't dressed appropriately to be on the playground. No, it was the firefighter day. So all the teachers were all dressed up in stilettos because of the firefighters. So they can't be on the field. You know, when the kindergartners have the firefighters, the teachers get excited. It was hilarious. But that's how Taekwondo was. Every single week, the mommies would come to Taekwondo like done. I take my kids to sports in a hat and rolling out of the car. There is dressing to like have one earphone and listen to a podcast. There is no dressing to impress when I'm bringing my kids to Taekwondo practice because honestly, Taekwondo smells like feet all the time. It just does. I don't know if it's all martial arts studios when you take your kids to martial arts, but it just smells like feet. But all the mommies would just be like, done. So Anton was fantastic. I'm gonna have to share his I'll have to share his Instagram on Insta so you guys can see Anton. He's a public profile because he is a stuntman and an actor. But anyway, that is my Bulgaria story. We would watch Dancing with the Stars Bulgaria when he was on it, and my kids would be like, "What is happening?" And I'm like, "No, you have to read. You have to read the subtitles. It's not in English, darlings. It's not in English." Susie Q, Fridays are back. I know. I'm so happy to be back on Friday. I am. Love it. So it's so good to see everybody. I'm having blue raspberry water ice wine cooler. That sounds amazing. Like that sounds like all the things I love and amazing. I can't, Cindy Thomas, that school board, I can't. We've lost the ability to respectfully disagree. And that is kind of killing me because in law, you can disagree with people. Like I get fired up because I'm talking to y'all, but in court, even when you disagree, it's like, we have to find a way to still work together. And I feel like we have to find a way to all still work together because we're not going to get anywhere if we don't all work together, even if we all disagree. And we're going to disagree about a lot of stuff, but we have to all work together. Peach Crown or Jim Beam, 7 Deadly Zins. Love it. I'm going to get a few of these and then we will go. Britain says, what are the rules about the truth in the court filings in Brit's case? Would Viv Matt be making claims in their filings if they couldn't prove truth? The interesting thing about the truth in legal filings. Legal filings are written in a adversarial way. They're written in the way to best support their client. Now, we've seen lawyers lie about shit. That I'm not going to say that has never happened. It happens. It's not supposed to happen. Misrepresenting things to the court can get you fined, sanctioned, investigated, and can escalate from there. You have an obligation to not misrepresent things to the court. However, how closely tied how you see a fact is always a thing. And lawyers are very skilled at taking a fact and being able to talk around that fact. So if it's based in a fact, but then massaged into something else in an adversarial way, that is vigorously advocating for your client. It's not blatantly lying to the court. Things that are blatant lies to the court or misrepresentations to the court will be brought up, but we see in civil cases a lot the attorneys saying, no, they're misrepresenting this, they're misrepresenting that. We've seen it in court cases we've gone over where we've read an email and we're like, this email says this, but this court filing presents it this way. And I don't think those two jive. But is that a lie or is that an adversarial wiggle? So they are obligated to not misrepresent things to the court, for sure. All right, before we get bogged down in super chats, we're going to have to get into topics. Wendy, said, my kids are going back to school and I'm going back to campus last year, full-time for my BA in film studies at 32, COVID, stay away. Fair enough. I can't imagine. We got the nails done today. And there was a lovely young woman who is getting ready to start her freshman year in college. And we had a conversation about the anxiety, the unknown, but the excitement of getting away, but the weirdness of people not choosing to be on campus or choosing to be on campus. It's still uncertain times, and uncertain times cause a lot of anxiety for all of us. It's not just y'all, it's me too. Anxiety is real, anxiousness is real, and the unknown of it all is absolutely real. And I am feeling it for sure. And I'm sure all of you are too. It's hard. I'm making plans for the fall. I have some conferences I'm supposed to be going to. And with that, I'm nervous about traveling still. I'm nervous and unsure about whether I'm going to book a bunch of travel and it's all going to get canceled. And I'm going to be on the phone for like 12 hours trying to deal with it. So we're just going day by day. We're going to talk about the legal stuff because like it's down on paper, it's documents, everything else feels very up in the air. And we're just going to see, like I've said in my podcast forever, the Emily Show, top 20 news commentary. Check it out. I love that a pop culture commentary podcast is in the news commentary section and it makes me giggle every time. Like, yes, I chose to put it there because it is news. It's the news we care about. But I've said for a long time, it won't feel like we're near the end of the pandemic till I get to go back to a Dave Matthews concert. This is a summer ritual for me. I'm obsessed. I am a Dave head. Look, I'm old. I grew up in the 90s. I don't give a shit. I love this band so much. And until I get back to a Dave show, it's still going to feel like weirdness. Well, they're touring this summer, and I have a lot of hesitancy about live concerts. Can you tell I've been streaming for days? I've been streaming for days. I streamed on Tuesday with y'all, which was amazing. Wednesday, I streamed with vidIQ. I mean, amazing. But Tuesday, Wednesday, yesterday, I streamed here. I streamed elsewhere. I was in a clubhouse room, back to school night, recorded some stuff, and then streaming today. It's just the voice is like, hey, welcome back from vacation. Dave Quinn. Hey, buddy. Good to see you. Day by day is the only way to go. I wish there was a BravoCon. I'm really sad that BravoCon got canceled. I was absolutely planning on BravoCon. Victoria, they're not just playing indie. They're playing Deer Creek. Deer Creek is a show I will be going to in future years. A lot of my Dave friends, that's their home venue or the venue closest to where they live. Deer Creek is an amazing venue for Dave. The Dave heads flip out for Deer Creek. So I will be doing a Deer Creek show at some point in the future. Danielle said, since finding your channel, it's gotten me back into law. I have a plan to go to school for law. Yay. It's just hard to find the right school. Keep looking. You'll find it. I saw another comment in the chat about somebody starting law school next week. Congratulations. Just take a deep breath. take a deep breath with law school, take notes, set boundaries, hydrate. It'll be great. Shan, I am a Labor Dave girl. I have gorged multiple times, and the Dave heads will know what that means. I have one more thing we have to do before we get all the way into we're going to do the latest on Britney first. So for everybody who didn't catch the full stream last night, I get it. It's a lot of content this week. Britney's dad, let me swoop. We're going to begin the weekly roundup. Let's just begin the weekly roundup. I'm going to try. We're professionals here. We're going to try to keep with the schedule. Did I tell you I was on AM radio this morning in Boston for Mix 104.1? They were fantastic. Carson and Kennedy were so great, but it was like I was up early. I've been talking all day and my brain has stopped. So this is where we all get to hang out and just have a drink and be friends. It's the best. That played weird on my end. Hopefully it didn't play weird on your end, but my stream kind of bobbled a little bit. And if my kid is Twitch streaming right now while I'm trying to stream, I'm going to find out. I will find out. So weekly roundup real quick. Britney Spears' father objects, gaslights, and maybe steps aside. And the point was made last night on stream. And the more I have thought about it, the point is just, it's so well taken that he's like, no, Britney's always been a partner in decision making, though there's documents to the contrary. No, Britney's always been, willing to do the things she's doing. No, I've never held anything over her head. No, we've never done this tit for tat thing. And his entire motion is once things like the 12th accounting are done, that's the only thing he pointed out, by the way, because that's the thing that's really the thing that's pending. Once the 12th accounting is done, the one that asks for $1.3 million in legal fees for Holland and Knight, 500,000 more of which is for Media Matters, of which there's tons of objections. Once that's resolved, then when the time is right, I will step aside. So, Your Honor, you don't need to grant the motion to remove me. It's like asking to resign before you're fired. It's like, no, don't fire me. Let me resign. I really hope the court just comes in and is like, no, you're fired. We're done. We're done with all of this. I worry that the court's going to be like, oh, yeah, let's resolve the 12th accounting before we yeet you. I am very worried that the court will think, yes, we need to do the 12th accounting first. I am concerned that they will address the 12th accounting and not address Dad Spears being removed. I am optimistic that Matthew Rosengart will be, the fuck, we're not going to do that. We're not doing that at all. We are going to deal with all of this together, and he does not need to still be here for the 12th accounting. But his lawyers will be like, no, we need to resolve these. And really, his lawyers are part of the objections for the 12th accounting. It does make sense that that gets done, but his lawyers can be allowed to appear for the purposes of the 12th accounting without him being the conservator of the estate. No one's going to argue that they don't have standing to continue wrapping up business. So I'm worried, but I think they can keep wrapping up business. So again, I have a whole playlist on Britney. I've talked about the 12th accounting a lot. The 12th accounting, every year there's an accounting of this estate where they give an entire breakdown of what has been paid, why it's been paid. This 12th accounting has been pending for well over 6 months at this point because there are objections to the legal fees paid. So we will see. I will go find over the weekend exactly which videos I talk about the 12th accounting in and highlight those on my community tab for you. It's time to talk about what's going on with Tati Westbrook. But before we get there, I'm going to share a little bit of an ad spot with you because you know what? NordPass has been so kind to sponsor another stream. They've been wonderful to work with. I really do like this product. And I have turned down, I always look at people when they say, like, you don't know what I've turned down. The things that come my way that I've turned down, I'm like, no, if your company has an F on the Better Business Bureau, just don't ask me to do sponsorships or ad reads for it. It's not going to happen. Just saying. Anyway, I am so excited to be partnering with NordPass. I really do like their product. I use NordVPN. I've shared that here on the channel before. So let's share it. They've got a great deal for you guys. That wasn't it. That was supposed to be it, but it wasn't. Today, I am so happy that this stream is sponsored by NordPass, and I'm really excited to share with you the NordPass end of summer sale that offers you 74% off and 4 months free. NordPass is amazing. It's brought to you by the cybersecurity experts that built NordVPN, and it goes beyond just a password manager. Yes, it will let you share passwords with your kids. So if they're like, Mom, what's the Minecraft password? You can be like, here's your Minecraft password and share it securely so you're not using the one real easy password for all of the kids' stuff. You know you do. I've done it. I don't do it anymore because I have a password manager, right? So you can share passwords with your kids or your family members or your team, but they also help create passwords, stuff that you would never remember. XZY exclamation point 329 3PO XYZ hashtag. And it remembers all of those, but generates them for you as well. I also love that NordPass has a data breach security scanner. So they will check those suspicious websites and tell you if you're about to enter information and be like, yo, not this site. You don't want to put your credit card in there. No thanks. Don't give them your birthday. Don't do it. We all know someone who can use this. My mom could use this, which is why we're getting her on NordPass too, because a password manager that's just a book in your top desk drawer is not the most secure way to do things, right? I love that the data breach security manager also scans the internet for your passwords or your credit card information that might have been breached or leaked. It's a really fantastic product. And there are so many things you can do with NordPass beyond just what I had time to list here. So thank you again to NordPass for sponsoring the stream. Don't forget to go check it out, nordpass.com, Emily D. Baker, or use my code. It's going to be here. It's going to be here. It's going to be here. Maybe over here, Emily D. Baker. And that will get you those 4 months free and a 74% discount now through September 2nd. So don't wait. Go get it. NordPass. All right. Let's get back to talking about some legal stuff. Bethany, did you find out if Dad Spears was paid for the 10th and 11th accounting? So the accountings were cleared. There weren't objections to any accountings until this one. The accountings are done annually at the end of each year of the conservatorship. So they finished the 12th accounting at the end of the year and then are still working on getting that accounting approved. All expenses in this conservatorship are approved by the court. So at the end of the year, Dad Spears has to, the company that puts together, these are what the assets are. This is how much money is invested here. These are what the deals have been. This is what money is coming in. This is what money is going out. This is what's been spent. It's a very, very extensive and thorough accounting. Some of it's under seal, some of it's not. There were a lot of objections in the 12th accounting. It seems like the 12th accounting is when Samingham woke up and went, oh, I object. Funny story. There was a mentor I had at the DA's office who loved to crack himself up telling lawyer jokes. And one of the running ones that he always said, he's like, look, just remember, if you're in court and you fall asleep at counsel table. Now, I know that sounds like that would never happen, but there are days when you're in a hot courtroom and you're like, I can't listen to anyone talk anymore. And he's like, so the first thing you do is you go, if you lose your place, you fall asleep, whatever it is, you go, I object. So it feels like Samingham was like, I object. That's what we do. I object to the 12th accounting, and that's mostly over legal fees and over some fees paid to Lou, Taylor, and TriStar. Tiffany, why is it called the 12th accounting? Because it covers the 12th year of the conservatorship. So yes, the chat was like, yes, we've already gotten that, boo. We got you. We got you. Let's talk about Tati Westbrook real quick. We're going to cover this more Tuesday. Here's why we're going to cover it more. Clark Swanson filed a motion to dismiss that's contrary to things he's already done and filed an extensive objection. It's like 400 pages long of an objection to Tati Westbrook's motion for a temporary restraining order. Now, the motion for the TRO or preliminary injunction is asking that he be forced to turn over corporate documents. This is Tati Westbrook's ongoing lawsuit in Nevada with her former business partner, Clark Swanson. He is still a 1/3 owner of Halo Beauty, but what we know from court filings is that he has been terminated from his role as CFO of Halo Beauty. There are 3 lawsuits that are active right now. One in California, one in Washington State, one in Nevada. Yep. One's a defamation suit in Washington between Swanson and the Westbrooks as individuals. When we went over that suit, I was like, all of these things are coming out of the same cause of action as the California suit. So why was this not filed in California? Well, probably because California has a really strong anti-SLAPP law. And so you would get into SLAPP and litigation, which is strategic litigation against public participation. It's a process where you can fight the lawsuit before getting all the way in. And if you win at that time, you get lawyer fees and stuff like that. So is there a little form shopping to file it in Washington? Maybe. Could it have been filed in connection with the California suit because it's all out of the same course and conduct? I thought so. And so then he files a motion to dismiss in Nevada saying, hey, this Nevada case should go to California because it comes from the same course of conduct and the same events. It should be counterclaims in California. Well, shouldn't the Washington case just be an amended complaint in California? Because Clark Swanson's suing the Westbrooks personally in that derivative lawsuit there. So why file one in Washington and then turn around and argue that they can't do what you've already done? What? So we're going to cover that more on Tuesday, and we're going to cover this 400-page, because there are emails, there is information that I think when I was starting to scan through it, I'm like, oh, we made that shit public. All right. Interesting that's what we're choosing to do. All right. It was like Swanson woke up and chose violence with that motion. He was like, burn the boats, burn the bridges, burn it down. But we also saw that approach in the California lawsuit, in my opinion, when he was, I think, spilling all of the information that maybe didn't make the Westbrooks look so great. Maybe could be looked on negatively. Maybe saying that Tati Westbrook said she could sell whatever shit to her fan base is accurate. But is it necessary for that lawsuit? No, it's a derivative suit. It's not necessary. But is it necessary to like, yep, seems that he thought that it was. So 426 pages. That was in court today on that motion, but there's not a minute order up yet. Yes, it was a public hearing. No, I didn't attend. I had a lot on my plate today. And there was a Duggar hearing today. There was a lot today. There was a lot going on in court today. It wouldn't surprise me at all if the court says, yeah, you have to hand over the corporate documents. I mean, you've been terminated from the corporation. There's litigation you have to turn over. And that's really all they're asking for is turn over all the corporate stuff. I'm interested to see the rest of Clark Swanson's kind of defense as he flushes it out in that TRO, because the TRO is like, look, you're doing this, you're doing this, you're doing this, you're putting people on payroll. So I think we'll get a sense of what his defense is to this case when we break that down more on Tuesday. And the reason I'm waiting on that is 426 pages. And we have other stuff to talk about tonight. But 2, because that minute order on the ruling for today's motion's not up yet. And I think it's helpful to just do it all at once because I expect that should be up sometime next week so we can kind of do it in time together. So that is what has happened in the Tati Westbrook case. I really do expect that we will see that minute order or at least a note on the court's website in the next few days. So, and I expect that the court will probably say, yeah, give them the documents. Like, turn over the American Express card, turn over the bank records, turn it over. And that's really it. That's what I think is going to happen. These 3 lawsuits are a mess. I think they're all going to end up in one court. The California lawsuit is already asking to be moved to Nevada. I think everything's going to end up in Nevada. Swanson's going, no, it should all go to California. Well, then why didn't you file the Washington case in California? Like, even you don't believe it should all be in California because you filed the other shit in Washington. Like, even you don't believe what's in your motion. So we're going to go through that more thoroughly. But we broke down a whole bunch of bullshit last night, so I need a minute, and we're going to get into some more bullshit tonight. So let's get into some more bullshit. Triller is not going to check itself before it wrecks itself. Sometimes I can stay neutral, sometimes I cannot. This case, I have no chill because some of this shit is just so ridiculous that I cannot. Let's pull up this case because Triller is not just suing. Oh, I hit the professionals, people. I hit the wrong professionals. We hit the wrong. Share screen. Just share the screen. Just share the screen. Thank you. Wonderful. Here we go. Triller has no chill. Triller is suing Ethan and Gila and Teddy Fresh and Ted Entertainment for defamation. Now, this is in addition to suing them for copyright infringement, alleged copyright infringement, over the Jake Paul Ben Askren boxing match. Yes, tonight we're talking about so much boxing. Why? Because so much is going on. You know, apparently when YouTubers box, there must be lawsuits. It's just what's going to happen. This is filed by the same law firm, Novian and Novian, but it looks, yes, they've listed all of the lawyers, but this is filed by the same law firm, Novian and Novian, that filed the federal lawsuit that had everyone improperly joined and is getting yeeted for that purposes. They are now just focusing in on Ethan and Gila. I think personally that this case isn't going to get very far. The problem is you can sue anyone for anything, even if your case is kind of a stinker, and it can cost people a tremendous amount of money to have to deal with it. So you can file a suit and then be like, do you want to play ball with this, or do you want to resolve it? I mean, it feels like extortion, but it's not, because it's filing a lawsuit for the purpose of getting someone to pay you to go away. So what would that be called? What would we call that? I feel like this is them being pissed off about the fact that Ethan and Gila are not intimidated and will not stop talking about this case. I don't think Triller is the only one intimidated by Ethan and Gila, but that is my opinion. Nature of the action, Ethan's face. I at first I was like, I have never seen a lawsuit start with pictures. I love pictures in a lawsuit. Like, I love pictures in a lawsuit, but the Nike lawsuit started with pictures of the Satan shoes too. So I'm like, oh, yep, okay. Here it is. This is from January 29th. This is War, H3 After Dark going live shortly. Foot soldiers assemble. I'm very, very curious to see how they think this ties into this cause of action. It seems to me that their entire point is that Ethan has riled the foot soldiers and they are actually going to war, as opposed to this all being kind of tongue-in-cheek with his audience. I would be shocked if the H3 After Dark from January 29th has anything the fuck to do with this at all. Like, I don't think this is relevant at all, but you know, because it was April that defendant publicly admitted that he bootlegged or pirated certain copyrighted materials, but you're not suing him for bootlegging it. You're suing him for re-airing it, but what he actually did was comment on it, which was fair use. So if you want to go after him for watching the stream, then what you can go after him for damages are the $50 fucking dollars that the stream would cost. But no, they're going after him for copyright infringement for fair use. In response, and to protect, don't forget, by the way, that Triller was the one that filed their initial complaint under a different LLC. Oh, they did it on this one too. Hold on, let me pull up the other Triller lawsuit real quick, because they did it on this one too. What are they, Triller, what are you doing? Why are you suing them from two different companies? This is not the same company. This is not the same company at all. So let me pull that up real quick in a separate tab, because then we can side by side it. Look, I can do that. I learned how to duplicate tabs in Google Chrome. I know that's very boomer of me, but I didn't know before that. So let's see if we can. Oh, good. Now it's, of course, why would it work? So angry. All right, we're gonna pull that up real quick because Google is like having a moment with me right now. It's like, we don't want to pull this up at all. No, but we need to. We need to because I will be stuck on this point and won't be able to get rid of it. So this is the first complaint, not the amended complaint. And it's Triller Fight Club versus the H3 podcast. Then they amend this. They amend this to be the actual company, TED Entertainment. In their second amended complaint, they go ahead and get this right. Triller Fight Club 2 LLC versus TED Entertainment. So the entity that's suing over the copyright infringement is not the same entity that is in this defamation suit. This, they just say Triller LLC. This one's Triller Fight Club 2 LLC. So who are we defaming? Oh my goodness. Oh my goodness. Who are we defaming? Those are two different companies. If there's an amended complaint that amends this to Triller Fight Club 2 LLC, amends this complaint, I am going to fall over laughing. I will literally fall out on that because you've done it again. This happened in the other lawsuit where they sued Mike, and Film Daily and everybody else. In that suit, they filed it under Triller Inc. first and then amended it to be under Triller Fight Club. So why would you make that same mistake again? This complaint is filing it under, this is the original Film Daily complaint before stuff got yeeted. This bugs, obviously the shit has been bothered out of me by this. They file it under Triller Inc., a Delaware corporation, right? And then when they get to the amended complaint, they've changed it to Triller Fight Club 2. So why in the LA suit are you back to filing it under the wrong fucking company name? What is happening? I'm gonna die. You guys, when this amended complaint comes down and I'm scream laughing on social media about it, you'll know why. You'll be here, you'll be like, oh, we know they filed it under the wrong company name, but they've made that mistake before. Twice. Oof. There's already a footnote. Certain copyrighted materials belonging to Triller Fight Club 2 LLC, Fight Club, in response and to protect its valuable copyrights and other business interests, Fight Club filed a lawsuit against Mr. Klein, Hila Klein, Mrs. Klein, TED Entertainment Inc., TEI, and others. I don't know why the footnote to the pirated materials are about DJ Screwdriver Media Post at Media Post DJ on Twitter. Like, what? Let's find out. We're going to all find out together. Let's all find out together. Oh, this is him purportedly talking about pirating it. He just said, I bootlegged it. I pirated it. Okay. So that's why that's linked. It's a weird. Okay. Either way, there we go. That's why they included it to detract attention from the copyright action. No, they made content out of the copyright action. No one detracted attention. Content. It was made into content. And in a deeply misguided attempt to exact revenge for the copyright action, what is this? And to gain an unfair advantage in the highly competitive entertainment industry. Mr. Klein, Mrs. Klein, TEI, and Teddy Fresh. What did Teddy Fresh do? They didn't even make a shirt out of it. I mean, in the Nike lawsuit with the Satan shoes, at least Mischief managed to make a shirt out of the complaint. They put the complaint on a shirt, called the shirt lawsuit, and sold it. Like, at least they made it. I have questions as to whether the front page of the lawsuit is actually the copyrighted materials and products of the lawyers, but at least they made it fun. And that's actually, benefiting from it. But does 1 through 500, it seems like an excessive amount of does, but okay. I think they're going to try to sue the entire subreddit. Hello, foot soldiers that are on subreddit. Maybe that's why there's does 1 through 500. They're going to sue all of subreddit or everyone in the H3 subreddit. They announced they were going to war with certain affiliates of Fight Club, including Triller LLC. In January, though? C and the Numbers of Baby is H3 After Dark number 40 H3 podcast, YouTube, June 11th and then they've linked it with the timestamp stating, this is the guy I'm going to war with now. But like, we're not actually like waging war though. Like that's hyperbole. While showing results of a Google search for Ryan Kavanaugh. We'll talk. Ryan Kavanaugh's involved in other stuff that we've covered on this channel. We're going to have to do like a deep dive at some point. I just have not had the bandwidth at all. In furtherance of that war, this is their argument. It's their argument. The argument is in the context of we're going to war. Fuck them. Okay. Is there a murderous conspiracy in this complaint somewhere? Hopefully we'll find it. Defendants instructed their rabid fans known as foot soldiers to leave thousands of negative so-called troll reviews for Triller's app on the App Store and Google Play Store, among other places. How is that defamatory, though? They're allowed to say, hey, I mean, it might be, you might have like a terms of use argument, but that's not like a lawsuit argument. But first of all, I would need to go look at the clip to see what I thought. They define troll, though, in the footnote. To troll something or someone is, quote, to write false or offensive messages on the internet in order to make other people angry. Troll, Oxford Learners Dictionaries. I love that troll has to be defined. Troll for something, to catch fish by pulling a line with bait on it through the water behind a boat. Troll something for something. He trolled the internet for advice. Troll for something. Both candidates have been trolling for votes. Troll somebody something, to write false or offensive messages on the internet in order to make other people angry. Someone keeps posting snide comments on the forum trolling for a reaction. Someone trolled me every day this week, each time posting the same obnoxious message on my blog. It looks like kids are intentionally trolling these blogs and trying to get a reaction from the adults that write them. Okay. But bad reviews aren't troll reviews. They're negative. What? Okay. Are they trying? I mean, maybe they are trying to get a reaction. Do you think they're troll reviews? Chat, replay crew, let me know. Do you think telling somebody to leave a review is a troll review? You let me know. The reviews are notable and clearly traceable to defendants because they are completely at odds with the reviews in the App Store for more than 5 years. And each of them explicitly parrots and implicitly references defendants and defendants' false, misleading, and malicious allegations concerning Triller and Mr. Kavanaugh. That's not defamation, though. For example, on May 21st, Reddit user, and then they cite the Reddit post. But I love that they were able to keep the emojis in. Like, well, okay. I love that there's colorful emojis that they do. Color instead of screenshotting, they copied it into here with the colorful emojis with all the Reddit users. Hello, Reddit users. Foot soldiers assemble. Tank the Triller app. The thing is, you can't hold Hila and Ethan for things that weren't said for defamation. They didn't say it. And this isn't defamatory. Now, whether there's also tortious interference with business, we'll see. But even then, it really is going to come down to what was said. And if they said, go rate the app, let them know how much you like it, that's not telling them to give negative reviews. But yes, this is a knife and a like a stick of dynamite emoji and a foot emoji. And the emojis are in the footnote too. This is an article about Ryan Kavanaugh. I want you to give Triller an honest review. The scare quotes surrounding the word honest utterly belie any defense that this post encouraged legitimate users of the app to have good faith reviews. How in the ever loving fuck are they going to prove that Ethan made this meme? Because honestly, with peace and love, I don't think Ethan's that good at Photoshop. I mean, I don't know if that's one of his skills. The thing about a suit like this is, though, they still have to pay their lawyers to deal with this. And we'll get into the defamation stuff and whether this can be a slap defense. And if it is a slap defense, they'll get their lawyer fees. And hopefully Triller is aware that if they lose the slap motions, that they will have to pay H3's legal fees. And I imagine that will be made into content too, won't it? To date, defendants have succeeded in artificially lowering the app's rating, not based on actual user experiences. And again, we'll see if there's tortious interference in here. Jurisdiction and venue, we're in California. Parties, Triller is a limited liability. So I wonder if this is because they didn't say which Triller. I wonder if this is the Triller owns and operates the app. So if this is the company that owns the app that's suing, so the app is being defamed? How? What? You can't. I mean, I guess they're saying the business is being defamed. But like there's no individual behind it. This is going to be very interesting. All right. They list who Ethan and Gila Klein are. I don't know how they're going to get to Teddy Fresh. Teddy Fresh? What? Alter ego allegations. I covered this in the other lawsuit. They're trying to pierce the corporate veil to get through and trying to say that that Teddy Fresh and TED Entertainment are not real companies. They're just kind of the shell companies for Ethan and Gila as individuals. Now that will fly with companies like maybe Erika Jayne's loan out company, but it's not going to fly in this context. And I will be literally shocked if it does. I don't know how they're trying to rope Teddy Fresh into this. Factual allegations. Triller is a provider of various entertainment and social media products and services. It owns and operates an app, a popular mobile application. Do you know anyone that uses Triller? Let me know in the chat. Oh, let's put up a poll. Tech, poll the audience. Do you know anyone that uses the Triller app? Yes or no? Let's leave that up until we get to the end of this complaint. It's definitely a complaint. It's like, Mom, they said mean things about us on their show. Triller owns and operates the app, a popular mobile application that allows users to share information and communicate with each other regarding music. Fight Club is an affiliate of Triller that is a copyright owner and publisher of the Jake Paul Ben Askren boxing event. In response to and retaliation for the copyright action, on or about June 11th, defendant recorded and published to the YouTube channel, which defendants own, operate, and control a series of videos, including And the Numbers of Babies Is, Trisha's Apology and Ace Family Scam, James Charles Returns and Baby Update, the biggest scam in YouTube history. They don't cite any statements. Do you remember when we went through the Tati Westbrook KJ lawsuit, and it was laid out with, in this article, this was said, in this video, this was said, on Twitter, on this day, this was said, with timestamps and everything. Like, you can see the difference in the lawyering and putting together a complaint like this when you get to compare different types of complaints that are coming from the same platform, seeing the way the lawyers lay them out. And we're going to get to that later with Ron Richards too, is the way that Erika's lawyers laid out foundation for Twitter is that they just ignored that was a requirement. So it's really interesting to see that they don't actually say what the fuck's in the videos. In the videos, which video? Defendants make false, misleading, and malicious statements. That's a conclusion. Against Triller and Mr. Kavanaugh, including that Triller is and Mr. Kavanaugh runs a Ponzi scheme. Well, that's a compound sentence And if Mr. Kavanaugh runs a Ponzi scheme, that's probably from this article, up here, because Ryan Kavanaugh was involved in the movie lawsuit that we talked about a little bit. And I'm going to have to, I'll pull it up. But the movie lawsuit that we talked about, he was, I think, one of the producers and did not have permission from the actor to release the film and went ahead and did it anyway. So okay. The Triller falsely represents that comedian Kevin Hart uses the app. But didn't they though? Like, wasn't that reported in like articles? If you repeat what's in an article and say this article says this, it's not defamatory. It's commentary that the app is flipped. That the app is flipped. Oh, thank you, Laura, the Terrence Howard suit. Thank you. Ryan Kavanaugh comes into play in the Terrence Howard suit as well. That the app is flipped. I mean, but wasn't the app like doing everything on mirror when you had your front-facing camera? And that Mr. Kavanaugh bears a physical resemblance to Harvey Weinstein, a notorious convicted sexual predator. The words bear a resemblance is a comparison on looks. So while it might be unflattering, it's not defamatory to the company. Look, we needed some levity this evening, and a lot of stuff that we're dealing with is very serious, and I can't take this lawsuit seriously. I can't. I cannot. Defendants also state that Kavanaugh is suing them. Mr. Kavanaugh has never sued defendants. But is Mr. Kavanaugh the head of Triller and Triller suing them? In the videos, defendants misrepresent a June 7th, 2019 article in Variety magazine and claim that Variety article purported that their statements that Triller is and Mr. Kavanaugh runs a Ponzi scheme. Defendant's statement that Triller is and Mr. Kavanaugh runs a Ponzi scheme are false, misleading, and malicious. Well, can you quote it? Where's the quote? What did they say? Not like what you think they said. What did they say? What are the words? Where is the timestamp? Not that a judge would do any of that. A judge is not going to go look. But y'all can be like, no, that's not what was said. You can play along on your bingo card at home, but they didn't include the timestamps, and the judge isn't going to go look, and the motion to dismiss or the slap motion is going to be very interesting. Indeed, the Variety article defendants purportedly base their false, misleading, and malicious statements upon. Oh, they acknowledge that there's a source for the statement. Neither mentions nor references Triller and expressly and unambiguously disavows any claims regarding a Ponzi scheme. The retraction, which is contained within the Variety article itself, states in pertinent part, Spar apparently has some regrets as well, saying that Kavanaugh is not really running a Ponzi scheme, as he alleged in his suit, which is also posted below. Ryan has been funding ESX operations himself. To my knowledge and based on information provided to me, Ryan has and is investing heavily in this business, and any reference to ESX or any related business as a Ponzi scheme is not accurate. He is a visionary thinker, and I wish him the best of luck in future endeavors. Why does that sound like a settlement statement to me? I wouldn't be surprised if after the article came out, there was a conversation about that. I would not be surprised about that. But who knows? In videos, defendants encourage their viewers and fans, aka the foot soldiers, to leave 1-star ratings for the app en masse, which again might be violation of terms on YouTube. But if they're encouraging an honest review, it's different. Oh, there's a quote. For example, Mr. Klein states, so I've been having fun looking up Triller. Like if you go to the App Store, I gave them 1 star, by the way, just because I don't have a positive experience. So if you don't have a positive experience and you leave a 1-star review, wouldn't that accurately reflect your experience? Yeah, but people should judge for themselves. Why is that part not in italices? He literally said that people should judge for themselves. So that's not telling people. It says in the complaint, it says, but people should judge for themselves. What? Right. So he's not telling them to go leave negative reviews en masse. He's telling them to judge for themselves. What? Go download the app and leave a review. The quote itself is not actionable. This particular quote is not actionable. Why is it in there? That quote itself belies this litigation for that quote. Thereafter, defendants show on the screen and read to viewers purported reviews of the app, some of which they themselves wrote. Nearly all of these reviews parrot defendants' false, misleading, and malicious statements concerning Triller. How do you prove that? How do you prove some of which they wrote? How do you know? Okay. During the July 8th video, Klein appears before a background that contains, among other things, a review for the app left by Ethan K. Ethan K's review states, using Triller has been one of the worst experiences of my life. I would rather... This is in a lawsuit. I went to law school for this. Oh my God. Okay. I would rather get I'm sorry. I would rather get a colonoscopy from a chain link fence over having to use this software one more time. I would rather get E. coli from from a dirty Sanchez on a scorching day in Death Valley instead of trying to operate this TikTok knockoff ever again. Actually, Triller and TikTok are in litigation. I don't know if it's resolved yet. I'll have to look. I'm sorry. I would rather listen to David Dobrik's Luciferian demon laughter play on a loop as my ears bleed in some sort of hellish vlog night terror I can't wake up from instead of logging into the Triller app. Also, I heard that Ryan was involved in a Ponzi scheme, according to his former business partner, allegedly. 1-star app. It just... Mom, they left a mean review on our app and they don't like us because we sued them over fair use. Okay. Defendants go on to incite their foot soldiers, extorting them by saying, wait, did I read that right? Exhorting them by saying, I'll be checking in on Triller reviews and asking that foot soldiers try the app, see how it goes, and give it 1 star or more. Laughter. 1 or more stars. Some amount of stars between 1 and up to 5 stars. Download the Triller and rate it 1 star or more. Laughter. That's what I did. How are they going to prove this? And at what well, okay. Oh my God. Although defendants state, holy shit, they're just proving they're proving the defense in the complaint. The motion to dismiss, I think they'll probably do a slap motion, but the motion to dismiss would also be epic because the complaint proves that it's not defamatory. Although defendants state, quote, we do not condone and we do not encourage troll reviews like this one, defendants' visible and audible laughter while making the aforementioned statement, coupled with defendants' promotion of various supposed troll reviews, and promise to continue checking in on Triller reviews and be back every episode to review the reviews, reveals defendants' true motivation to inspire foot soldiers to leave troll reviews. This is a lawsuit. Adults wrote this. Lawyers wrote this. They're trolling our reviews But is it defamatory if people use the app and think it sucks? Indeed, just seconds after purporting to disavow troll reviews, defendant joked that their foot soldiers would never brigade such a website on command of their there's no precedent for that. How did we get that name again? As one article, there's a footnote. As one article notes, brigading is a term that originated on Reddit for a coordinated attack by a group of users of an antagonistic subreddit quote, are they defining subreddit within the definition of brigading? Subreddit, form dedicated to a particular topic. I mean, I think that oversimplifies things. The brigade would privately agree to downvote comments either on a random or targeted basis to deprioritize them in users' feeds and effectively censor them. Okay, this is how subreddit works. The meaning of the term expanded to cover all coordinated voting behavior and make something or someone seem more or less popular than they actually are. I mean, isn't that what door-to-door canvassing is during political season? Like, hey, we'd sure love it if you vote for so-and-so. Isn't that just the same thing? The meaning of the term expanded to cover all coordinated voting behavior and to make something or someone seem more or less popular than they actually are. Well, how do you know if it's more or less than they actually are? Okay. And now it means all coordinated abusive engagement behavior online. It does. It means all abusive behavior online. This engagement can come in the form of retweets, comments, quote tweets, email campaigns, and more. I mean, people do that. People also use Discord for that. Okay. I said, okay. Okay. Upon information and belief, there's a substantial precedent for defendants' foot soldiers brigading websites on defendant's command. The foot soldiers are malleable. The foot soldiers have no independent thought. The foot soldiers just, whatever Ethan says, the foot soldiers must do. Indeed, approximately 1 year ago, Business Insider reported that Old Spice dropped its sponsorship of H3's Ethan Klein amid a brewing troll war with Keemstar. How does that prove anything? That Old Spice dropped its sponsorship of Ethan in a war with Keemstar? How does that prove that the foot soldiers get things done? Because if Ethan lost his sponsorship, doesn't that prove that Keem's audience trolled him? Isn't that what that says? Am I crazy? I feel manipulated. I feel attacked personally by the way this is written. Old Spice dropped its sponsorship of H383's Ethan Klein amid a brewing troll war with Keemstar. So did Keem's audience get the sponsor to drop Ethan? Because how does that have to do with anything? As Business Insider reported, following a spat between Mr. Klein and Keemstar. I like that it's Mr. Klein and Keemstar. Keemstar doesn't even get his actual name in this lawsuit. Another YouTube content creator, quote, Klein went on to produce a video about Keem titled Content Nuke that accused Keem of lying about Klein committing fraud and additionally compiled examples of Keem's offensive behavior in the past, including a controversial interview with a YouTuber who would, oh, Jesus fucking Christ, who would later die by self-harm, where Keem apparently appeared to suggest, what does a feud between Keemstar and Ethan have the fuck to do with alleged troll comments on the App Store? Business Insider further reported that after Content Nuke's debut, G Fuel, a longtime sponsor of Keemstar's, social media profiles were spammed with comments asking for the energy drink company to end its sponsorship of Keem. Is that the point? Is the point that the foot soldiers asked the drink company to end their sponsorship to Keem? Or was it Keem's comment about the other YouTuber that was pointed out in the article that was the problem? And why the fuck is this relevant to literally anything? Why is the beef between Ethan and Keem relevant to literally anything? Because defamation is like what you did, what you said. What you say. Nothing in this is, they have not said anything Ethan said except for him saying, obviously download the app and maybe give it 1 star or maybe more stars. Everything he said in this is not defamatory yet. Tammy says, I'm offended by this lawsuit. Can I sue? I mean, I feel personally attacked by this lawsuit. Defendants plainly sought to lead by example, including by posting their false, misleading, malicious allegations on social media outlets, including Twitter and the H3 subreddit. Prove that they posted it on the H3 subreddit. Prove it. Prove it. Good luck with that. They're actually including the Reddit users in here saying that Ethan posted it when they're including the users that posted it. Are these individuals Ethan Klein's subreddit username? Just like you can't have like vicarious defamation where you say that Jeffree Star and Shane Dawson also said mean shit about Tati Westbrook, therefore they should be sued too. You can't say a bunch of people on subreddit said mean shit, so now I'm going to sue Ethan about it. Mom, they're being mean on subreddit. Guess what? People are mean on the internet. What? People are mean on the internet? The fuck you say? Defendants' foot soldiers, they're not letting this go. Defendants' foot soldiers listened to and followed defendants' instructions. They're trying to make some kind of like reach to like a January 6th signaling argument. Like that somehow Ethan is dog whistling his foot soldiers to create harm in some way. When what he said was, give it a 1-star review, give it a 5-star review, try it, see if you think it's crap, see if it's flipped. I just defendants' foot soldiers listened. Thousands of new reviews have been left for the app on the Apple Store, but what they didn't seem to attach, and this I've seen done in other lawsuits, not well or successfully, but where you leave the metrics and show, hey, on this day we had this many reviews, and on this day it had this many reviews. Look at the spike. He said this, and there was a huge spike that day, and all the reviews were negative. Show your work. If this happened, it will leave a trail and you'll be able to see it. But even then, probably not defamatory. Because they're saying, leave a review, use the app, see if you like it. Moreover, nearly all of these new reviews explicitly and implicitly reference defendants and parrot the same false, misleading, and malicious claims. Are we going to show harm, though? How do you show harm to the app? How are they going to quantify the harm? The negative reviews aren't the harm. How are they going to quantify it? Because they've not seen or said anything that quantifies harm to the plaintiff at this point, other than their feelings seem to be hurt. As a result of defendants' false, misleading, malicious statements, Triller has suffered damages, including lost opportunities. What lost opportunities and what damages? There's nothing specific stated. It's just a conclusory statement. There's been damages. You have what? Reasonable persons would look down upon defendants' contemptible, despicable, and malicious conduct alleged herein. Oh, it's outrageous. We'll get to those charges in a second. Yes, we will. Intentional interference with existing economic relationships. Whoop, there it is. Defendants were aware of Triller's status as a popular video sharing social network service app. Can't wait till we do our poll. Its existing economic relationships and business opportunities. They engaged in the conduct. Plaintiff has lost certain existing economic relationships and business opportunities. Which ones? They're going to have to prove which ones. They're going to have to prove which ones. Say, I lost these things because of this. Prove it. Intentional interference with prospective economic relationships. So then there had to be a existing business opportunity that left. What was it? They should know that if they're alleging it. Prospective economic relationships is like, look, this is so outrageous that it could make people think less of the app. Okay. Third cause of action, negligent interference with existing economic relationships. Like, look, you were so negligent in doing it, you knew that you were hurting us. Negligent interference with prospective economic relationships. Look, you shouldn't have done that. It's not intentional, but it was at least negligent. The problem with the negligence is if these things have, if there's an article that they're referring to, if there's those sorts of things, it's going to be hard to show that this was negligent. If the statements being made reference back to other things and aren't just made up out of the blue or are comedy or are parody or those sorts of things. And I think the review is kind of comedy. Violation of California Business and Professions Code. That this is fraudulent business act or practice, any unfair, deceptive, untrue, or misleading advertising. Defendants engaged in unlawful, unfair, and fraudulent business acts or practices by making and disseminating false, misleading, or deceptive statements concerning plaintiff to the public. But the app was mirrored at some point. And what other statements are misleading? Is it misleading that Ethan would rather get a colonoscopy from a fence? Because that's opinion. And that's it. And that's it. This is so conclusory. There's just no, there's a lot of like, Ethan said mean shit and we've been damaged, but there's no proof. So the violations of business and professions code is regarding the unfair business practices for the making the statement. So not a full true defamation suit, but the interference with economic relationships. So, hey, this suit is really like, hey, you said mean shit and it damaged our business. So it's the business equivalent really of interfering. I don't know how they're going to prove more than an App Store rating or correlate an App Store rating to actual damages and prove that that rating is not because of valid use. If the like reviews cover the same kind of things that had been complained about before these statements were made, it'd be easy for Ethan's legal team to say, look, these statements were made before, these statements mirror it. This is a user experience issue. This is not an us issue. This is still, the thing is, even though this is ridiculous, this is still going to cost the clients and their businesses money. And how did any of this relate to Teddy Fresh? None. The poll has closed. Do you know anyone that uses the Triller app? No, 98% with over 1.6 thousand votes. 1,600 votes, 98% of you don't know anyone that uses the Triller app. I'm just saying, that wasn't supposed to be a deep dive, but it was too ridiculous to not to. So I think that this is going to cost them money, because Teddy Fresh is going to need an attorney because they're a separate company from TED Entertainment. Yes, they can waive and work with the same attorney, but Teddy Fresh is going to have different defenses if they choose to than TED Entertainment, because TED Entertainment is going to be what's covering the podcast. So that's actually the proper entity, where I don't think Hila and Teddy Fresh have any relevance to any of this at all. And I think that they should get yeeted immediately because they're, just dismissed. It has nothing to do with them. And then look at the slap, anti-slap. But this is just, and I think stuff like this is going to further damage Triller's reputation, because stuff like this continues to be like, really? You're mad. You're suing Ethan Klein. And think what you want about Ethan Klein. that it's really not relevant to this lawsuit, but you're suing Ethan Klein for a statement that doesn't seem to be related to this lawsuit because it was made in January, and for memes that are posted on Reddit that he didn't write or post. So his statements, the only statements of him that are really highlighted in this indicate one, that he wrote a review that had a lot of hyperbole in it and was, again, clearly meant to be a joke in part, but also express his experience. And two, um, he said people should judge for themselves. Okay. People should judge for themselves. How is people should judge for themselves interfering with anyone's business relationships? Judge for yourself. I didn't like it. You judge for yourself. You're still allowed to make reviews. You can grab a product. I mean, you can grab a product and be like, I didn't like the way this worked. Not my favorite. That's my opinion. Try it for yourself, but I don't like this. You're allowed to negatively review something. Yes, you can be sued over negative reviews. I have a podcast episode all about the prevalence of lawsuits with regard to things like Yelp and suing people over negative reviews. But those types of negative reviews that are sued over on things like Yelp tend to be, this owner is insert medical diagnosis. This business is insert outlandish, factually stated claims. It's not, I didn't like this. I didn't have a good experience. Judge for yourself. So this is really a sued for a negative review lawsuit, just like the Yelp lawsuits. Okay. Okay. Great. Great. We took a poll about what we were going to get to next after I got through these three. So I'm going to take a look at that poll results. And the order of the next ones are Duggar, then Girardi, then McBroom. All of you are like, yeah, we don't care about Austin. So we'll see if we have time. We might not. Duggar, then Girardi for sure. And it's already an hour and 15 minutes in. So we might not have time for McBroom, and it will get bumped to Tuesday. It's a lot of lawsuits. There's a lot of financial stuff going on with that. So yep. Let's get into Josh Duggar. Josh Duggar, well, I should swoop. Everybody's like, Emily, swoop. Yep. Josh Duggar was back in court today. Well, his legal team was, at least. I have not seen a minute order on that yet, but I expect one will be up either. Well, I can actually look as I'm doing this. But what's going on in that suit is discovery. So there is a motion to compel the government to turn over more stuff. Duggar's attorneys are saying the government hasn't turned over enough. The government's saying, but we did, though. And the court's going to have to rule on that motion to compel. The most interesting thing to me that's been filed in the Duggar case lately is the pretrial scheduling order that I'm going to pull up right now. In this pretrial scheduling order, we get some really key dates to mark down on your calendar and keep an eye on. That's what I'm going to be doing. This pretrial scheduling order indicates when discovery needs to be turned over, what types. Look at how detailed this judge is. I love this. This makes me so happy. The defense knows exactly what the government is doing, what they're turning over and when, what's being sorted out and when, exactly what materials. There's no room for confusion. This is what you're doing on this date. This is very, very standard practice. Not all judges lay it out so clearly. I really like this. It makes it clear for everybody. So the government decision not to disclose is laid out. Information the government is not required to disclose is laid out. Everyone's on equal footing. Everybody knows. We know what the defendant's discovery obligation is and when, other required disclosures and when. But then we get down to the motions section, and we get down to when we're going to start seeing dispositive motions by August 20th. Dispositive motions are motions that could yeet the case, motions that are capable of determining certain issues without being tried on that issue. So these are not uncommon in criminal cases, but those are due from the defense or the prosecution on August 20th under FRCP 12C. And then the motions in limine are due in November based on the new trial date. But what's super interesting is that there is a statement of the case due November 16th, and each party must submit to the court their proposed statement of the case. This is their rundown for the judge, one page in length. This case is about this. We expect to prove this. Or for the defense, this case is about this. We expect our defenses will be this. And it really lets the judge get on to concise footing before going into a trial. And then the change of plea date. The judge must be advised by October 18th, 2021, if there's going to be a change in plea. That is the last day to notify the court if Josh Duggar is going to not go forward to trial and to plea in this case. And they must sign the plea agreement by October 20th, 2021. So by October 20th, we should know if Josh Duggar has chosen to take a plea deal in this case or has chosen to go forward to trial. Right now, they are fighting over discovery. Hey, we want the government to turn over this information. They haven't done it yet. We think they're obligated to. That means the defense is still gathering all of the information before they make this decision. So we should know. I mean, we're in August. This is not that much time really between now and October, especially when we're talking about court, to know if Josh Duggar is going to plea. So in a little more than 2 months, we'll have an answer to that. I thought this was really interesting. A good date to note if you're keeping an eye on this case and want to know about the change of plea. This was filed at the end of June, but we've been tracking this case loosely here, not as closely as some others, because really when it comes to discovery, it's not a ton going on. It's did you file these motions or not? There is a declaration filed with that I'm going to look out a little bit more closely. If there's any, I started looking at it and it very much describes some of the materials that were available in this case. And I'm not going to pull that up on stream and go over it. I am going to parse through it, and any other nuggets we will do in a weekly roundup next week as well. I'm just going to peek and see if the court issued their minute order yet, because that hearing was at like 3:30 today, and they might have already issued that minute order. Let's see. Minute entry for proceedings held. Motion hearing as to Joshua James Duggar heard. Motion to compel filed by Joshua James Duggar entered. So they entered the minute order that the hearing happened. They did not enter the minute order of the result yet. And that might be because whatever the court ruled, they asked either of the parties to draw up the ruling or the opinion and say, hey, this is the minute order on what happened. So that might be why we don't see it yet. So we should see that. And hopefully by Tuesday, we'll have that up. And then on Tuesday, we can kind of swing back around and take a look at what's going on with this case. But October, mid-October, we'll know. Before Halloween, we will know if there's going to be a plea in this case or not. And that's a really interesting date to keep an eye on. I see over 3,600 of you on the stream right now. If you have not liked, do that. If you're not subscribed, make sure you double check that you are subscribed. YouTube has a helpful way of cleaning out your subscriptions for you. So like and subscribe. If you appreciate the channel, go ahead and share it with a friend. I'm also on one of the legal news websites that I use. I'm also seeing a breaking story that I'm just going to talk about real quick because it involves Apple and I'm fascinated. And the mods are like, girl, no. Just real quick. It's about Apple. After trial in Texas, Apple owes $300 million for copyright infringement. Well, patent infringement over 4G wireless. What? A Texas federal jury said Friday after a damages retrial means they were just retrying the amount of money, that Apple owes $300 million for infringing on Optus Wireless Technology LLC's standard essential 4G wireless patents. Right, we're already on to 5G, but this is just getting resolved. Following the U.S. District Court's April decision tossing an earlier $506 million damages verdict, expressing serious doubt about it. The jury said Apple should pay a lump sum rather than a royalty for infringing on a patent previously owned by Samsung, LG, and others. In the retrial, which started August 10th, the jury focused on a single issue: the amount Apple would have agreed to pay Samsung and LG in a licensing agreement to use the patent at $300 million. So Apple, in this appeal, saved themselves $200 million. Interesting. Still a lot of money, not a lot of money to Apple, but I saw that come through as breaking and I was like, ooh, squirrel. Squirrel. Let's talk about Girardi. McBroom's going to just have to get bumped. I'm sorry if you're just here to hear about the McBroom Doom lawsuits. He's being sued by LiveX Live. Simply Greatness is suing LiveX Live. Taylor Holder and others are suing him. It seems that James Harden said he's suing him and isn't, and we'll break down those lawsuits. People haven't gotten paid yet over that Social Gloves boxing event. So that's what we're going to break down. And then let's get to the Girardi stuff, because the court literally threw the smackdown on Erika Girardi. Literally. Yeah. Erika Girardi's fighting with the lawyers. When you say don't rile the lawyers, it doesn't just mean on social media, but she's done that too. Anytime you call someone a lawyer, it is going to rile them. And though I don't agree with everything that Richards has tweeted out, it is not the way I would always do things. Look, you have a right to use your Twitter within the boundaries of what the court has said that you can do. And that is what Richards has done. And the court has said, I said what the fuck I said in the last motion. So Ron Richards, who is a Twitter commentator and also practicing attorney, has commented quite a lot on the Girardi case before he was hired by the trustee in the Tom Girardi law firm side of the bankruptcy, the Girardi Keith side, to be the special assistant, special litigator who's just going after Erika Girardi. He was hired by the bankruptcy trustee with the approval of the court to go after assets for Erika Girardi. That means he is fronting his own money really on contingency with this case to track down her assets, do depositions, figure out where the money is that was owed to the law firm or is believed to be owed to the law firm. And then he will get up to 45% of that if it's recovered. We've seen a lot about whether or not her company took in $20 million over time from the law firm. If her company did, and if that is tracked down and proven, then that is a loan that her company has to pay back to the law firm so the law firm could go pay its fucking debts. So he was hired. There was a lot of kind of eyebrow raising about it because he does go hard on Twitter with regard to this case and others. And Erika's lawyers told the court, no, there's a conflict here. The court found no conflict. The conflict that they thought that there was with regard to the actual money. The one thing that I was like, actually, if any of these things are going to be a problem, it's that issue had been resolved prior to him coming into the case and prior to Erika Jayne's lawyers filing that motion. After he came on the case, more shit happened on Twitter. Erika's lawyers were like, Mom, he's saying shit on Twitter again. Please reconsider. And again, some of the stuff on Twitter is like, there's a gray zone in there that I might not be comfortable backing on up into, but that's not my decision. It's not my Twitter. And the court has said, look, we take Ron Richards' side in this. We think Erika and her attorneys are needlessly trying to delay the investigation into her. So we are not going to issue a gag order. We're not going to yeet him off the case over Twitter. And I think one of the mistakes that Erika's lawyers made was they did not adequately establish foundation for a bunch of screenshots from Twitter. And we've seen other motions that have brought in stuff lawyers have said on Twitter, that have brought in things that were said on social media with extensive foundation, mostly in the Tati Westbrook defamation lawsuit against Without a Crystal Ball. And those Twitter things you saw in those declarations. I use Twitter. This is how I use Twitter. This is how this was collected. This is proving that these things are being said on Twitter and laying a foundation for such. You can't just bring up a screenshot and be like, see, this is true. It's not how the fuck foundation works. So let's look at this memorandum of decision. It's quite extensive. The shorter bit is the court saying the motion's denied. The court was not thrilled and had some strong words for this. And it kind of signals where the court's at in this whole thing. And you know where the court's at? The court's had an ass full of this motion and doesn't want to hear about Twitter anymore. That's where the court is. Let's get into it real quick. Specifically, Ms. Girardi asks me to reconsider my decision to grant the Chapter 7's trustee application to employ Mr. Richards as special litigation counsel in this matter, vacate the employment order, and appoint new independent counsel and non-conflicted counsel to represent the trustee. She cites newly discovered evidence of events occurring after the hearing on the application approving Richards' employment and the entry of the employment order. The newly discovered evidence apparently, warning, danger, danger. When the court says apparently, it means you have not proved to them that you have evidence. Apparently is not the word you want to see the court using. Apparently consists of recent alleged false and inflammatory social media posts and public statements about Ms. Girardi. Look, I understand why she doesn't like the posts. I totally get it. But, and they say that Mr. Richards failed to allege or failed to comply with bankruptcy disclosures requirements by not disclosing his participation in a publicly aired YouTube video regarding Ms. Girardi, among other people, in his employment application. I thought that their issue was that he did not disclose he took part in the Hustler and the Housewife documentary, but they took issue with what he said in the YouTube video with Up and Adam. Shout out. Hi, Up and Adam. Love coming on your channel talking about housewives. But I don't think the court going to link you in this. I'm sorry. Other shout outs will have to remain. But I think their issue was not disclosing the participation in the documentary. And then the statements made on YouTube were the issue. That's how I read it. This is how the court reads it. We default to what the court says. Ms. Girardi further contends that Richard's conduct has damaged the legitimacy of the bankruptcy proceedings, unfairly prejudiced her rights. This, of all the arguments, and I broke this down pretty thoroughly the first time it came up on my podcast with regard to whether these were problematic pre-trial statements that could cast Erika in a certain light. And you have to be careful with that. But the court's saying this is not a problem. Yes, Erika is entitled to a jury trial in this, but whether the statements on Twitter are going to unfairly prejudice her is what the court has to address. I find the motion totally without merit. Things you don't want to see the court say. Shut the fuck up with this. That, with all due respect, shut the fuck up with this, is what the court said. I find the motion totally without merit. It appears to be nothing more than a blatant attempt by Ms. Girardi to impede Richard's efforts on behalf of the trustee to investigate alleged fraudulent transfers of the debtor's assets to Ms. Girardi and to prosecute the action against her for recovering those transfers for the benefit of the estate. The court is having legitimately none of it. And I think this gives us a insight, which is part of why I wanted to cover it. First, only fair. I've covered the rest of the motions. I've talked about this stuff on Twitter. We've talked about Erika's lawyer said jihad of tweets. Like, that happened. They said that. But we've talked about all of that. So it's only fair to cover what the court said. But the court is like deuces. And I think if I'm Erika and her team, it's time to back away slowly and try not to piss the court off anymore. The court's already not going to be thrilled seeing what Tom Girardi has been doing with the firm. This is the judge overseeing the law firm. Judges are lawyers before they are judges. So when I get riled on stream going, why the fuck did any of this happen? A judge is doing that in their head too, watching this unfold, watching the clients not get paid. That doesn't mean they're prejudiced against the case. It means that they are human and they're going, why is this happening? And so when the party that is a party they are trying to extract money from to get it back to the parties comes in and starts fighting with this, the judge is not entertained. They are not thrilled. And the judge, in their languaging on this, made it very clear. There is no clearer signaling than I find the motion totally without merit. It's nothing more than a blatant attempt by Girardi to impede Richard's efforts to investigate her. And that's what Richard said in his motion. And this is, the court took the language from Richard's motion and said, yeah, I agree with you. So that does not bode well for Erika as she moves forward, because now they have to re-ingratiate themselves. You do not want to piss off the judge early on in litigation. If the judge is saying things like, I've considered all the factors, And when weighing the law and the facts, I come out this way. That's not pissing off the judge. That is literally the law says this, you say this, you say this. I'm calling it here. This is why in the fuck did you waste my time with this Twitter shit? This is strongly worded, and that is not beneficial for Erika, which means it's probably good for all the people trying to get money back out of the Girardi Keese law firm, which might also be Erika if the law firm owes her money too. Turnabout. Background. The videos are on my channel. We've gone over these. We've gone over the application for employment. We've gone over the motions. We've gone over the other motion. We've gone over the new lawyers. We've gone over the gag order. The court says for the reasons set forth above, the court is denying the application. They don't agree. Despite the fact that I approved the application at the June 8th hearing and made it clear that at the time I would not limit Mr. Richards' First Amendment rights, Ms. Girardi, through her new attorney, now makes meritless arguments, including inter alia that numerous new alleged tweets should somehow disqualify Richards from representing the trustee. Footnote voice. I have sustained the evidentiary objections regarding the substance of the alleged tweets. Nevertheless, I will discuss the issues of the tweets for the sake of a complete record. My rulings on the parties' evidentiary objections to the declarations filed in connection with this matter are set forth in Exhibit A. The court literally goes through each thing and rules on each evidentiary objection because Richards and the trustee went thoroughly through this is no foundation, this is no foundation, and made all those evidentiary objections and took the time to do so, which is well done. As stated in the introductory section above, I find the motion totally without merit. Ooh, we said it twice. And accordingly issue this memorandum to explain my denial of the motion. I said what I said. Let me be heard. Let me be heard. I'm going to give you a whole memo on why the fuck you're wrong. Not just a one page. This is an entire memo ruling to make the record clear because what this judge is doing is protecting this case from appeal down the road. If it's found that Erika got monies and if it's found that they're going to try to extricate the monies, if she wants to object down the road, see, the court should have done this. The court is making clear to protect whatever comes next. And I think that that's necessary in not only a high profile case, but a case with so much money at stake. Ms. Girardi's standing to file a motion. Both the Chapter 7 trustee and litigation counsel argue that Girardi lacks standing. They argue she's not a person aggrieved. I agree that Ms. Girardi's standing to bring this motion is questionable at best. At the June 8th hearing on the application to employ, I expressed some question as to whether Ms. Girardi had standing to file her opposition, but assumed for the sake of the application alone that she did. I have applied that assumption solely for this motion as well. I'm not going to get into standing because other grounds are problematic, but I told you it was shaky then, and I'm telling you again it's shaky now. Newly discovered public statements. Girardi argues that under FRCP 59E, that the newly discovered evidence of statements and posting made by Richards on Twitter after the hearing allegedly violated any number of ethical norms. Footnote 4. Exhibit A attached to the reconsideration motion consists of a compilation of various social media posts about Ms. Girardi made on Mr. Richards' Twitter's account. The court notes that it has ruled that this compilation is inadmissible. See evidentiary rulings attached. What you didn't do was lay a foundation. What you didn't do. You can't just bring shit into court and be like, see, I've talked about in Jen Shaw coverage, I think I talked about this with Up and Adam, how long it can take to really establish a good foundation for these types of things. How do you know it was uploaded to the Twitter account? How did you know that the person said it? How did you know that you've accurately downloaded it? We saw when Mr. Brown, KJ's attorney, downloaded an entire Twitter account of Salt. They had an expert file a declaration saying this is the entirety of the account as it exists publicly available today. This is how I preserved it. This is how I downloaded it. This is how I did it. It wasn't a screenshotted snippet compilation. It was a completely professionally downloaded thing. While I disagreed with the purpose it was used for, they sought to have a foundation for it so that it could be admissible in court. That didn't happen here at all. And we talked about that when I covered Erika's motion. Though it was fun going over all the tweets they thought were shady, that was entertaining. There was still no foundation. So all of those tweets have been yeeted because they're inadmissible. So the court's like, no, I can't rule on those. There's nothing to rule on. Once it's inadmissible, it's like, whoosh, it's just air. There's nothing to rule on. I can't rule on it. It does not exist. It's nondescript. It does not exist. It's non-existent, if you will. They're going through the trustees' arguments. In his opposition on the trustees' behalf, Richard similarly argues the statutory provision cited does not apply. The court recites Richard's arguments as well and then says, I agree with the above arguments made by the trustee and her special litigation counsel, as well as with certain admissible statements. 5. The court ruled certain statements in Ms. Joyce's declaration to be admissible and other statements to be inadmissible pursuant to the FRCP, the Federal Rules of FRE, the Federal Rules of Evidence. The statements quoted in this memoranda are exclusively the ones deemed admissible. So let's get up to what the court actually found admissible. In Joyce's supporting declaration which expressed her professional opinion based on her years of experience as a state bar prosecutor, Mr. Richards' conduct failed to violate any ethical rules. They did not, Richards and the trustee did not take this motion from Erika's attorneys lightly. Because there's a lot to be. Richards, I'm sure, has invested a substantial amount of time and money already to investigate this case. And the only way you recover that is to get the money out of Erika and put it back into the law firm if that's where it belongs. That's when you get paid. You have to get the money and get it back. So all the time and money spent at this point, if he were yeeted, would be lost. So there is a reason to take this very seriously, but actually had a declaration from the state bar that the court considered in part. For example, Joyce declared that I have reviewed the motion and the serious but unsupported allegations against Richards made in the motion, and it's my unequivocal opinion that Mr. Richards, acting as special litigation counsel, committed no ethical misconduct as alleged. Joyce testified that she reviewed many complaints concerning purported ethical violations during her years-long career as a state bar prosecutor and found Girardi's complaint meritless. Quote, having reviewed many motions seeking disqualification in my previous role as a prosecutor for the state bar court, I believe counsel for Ms. Girardi's motion is frivolous, lacks merit, and was filed for the improper purpose of harassing Richards and causing undue delay. Based on her review of the motion, she believed that in this instance, quote, the motion's premise is based upon a faulty assumption that attorneys may not comment on cases. Well, there it is. Joyce concluded that Richard's conduct did not violate any ethical rules or norms. Quote, it is my opinion that Richards is not in violation of California Rules of Professional Conduct Rule 3.6 in whole or in part, nor is he in violations of Business and Professions Code 6068 in whole or in part. In sum, the arguments of the trustee and her counsel and the statements by Ms. Joyce fully support my conclusion that Richard's conduct failed to constitute any ethical violations that would disqualify him from representing the trustee. Failure to disclose participation in a YouTube video. What's up and Adam? We're going to just get to what the, this, I think by the YouTube video though, they might mean the documentary because they start talking about Kim Archie and she was in the documentary. The trustee disagrees with Girardi's assertion that the inclusion of petitioning creditor Kim Archie in the YouTube video. I think they mean The Hustler and the Housewife, which was the documentary, not the YouTube interview that he did. So I think it got conflated a little bit there. But in context, we can figure it out. Because Kim Archie wasn't in that Up and Adam interview. She was in The Hustler and the Housewife, and that's the context where this came up. The video constituted newfound evidence of an inappropriate connection with the Richards firm, which should have been disclosed. The trustee points out that Richards did not know that Archie was being interviewed in the same documentary. There we go. Until after it was aired, and his firm could not have disclosed a fact of which it had no knowledge. The motion failed to provide any evidence of such knowledge at the time. Yeah, Richard said he didn't know that Kim Archie was in The Hustler and the Housewife until it aired and he saw it, and that he was cut out from that in any case. They go through Richards' argument more. We've already gone through these arguments when we covered that motion and the objections. I agree with the arguments. Something on my computer is being loud. I apologize. Just turn the volume down. Again, I agree with the arguments of the trustee and her special litigation counsel. There was simply stated nothing for Richards to disclose. Let's get to the Twitter's alleged prejudice of newly discovered public statements. The Twitters. Girardi argues that Richards' public media statements about her prejudice her rights through public vilification, which appear intentionally designed to destroy her right to defend herself and assert her rights in this proceeding. She believes that a significant likelihood exists that Richards' barrage of social media postings. I'm bummed he didn't quote the one that said jihad, but okay. I would love to know the court's opinion on that. Barrage of social media postings and public statements will improperly prejudice any potential jurors. I find this argument speculative at best, given the sheer size of a potential jury pool in the county of Los Angeles, which Richards pointed out in his motion. Look, LA has 10 million people. My Twitter has 20,000, and they're not all in LA. And that's for sure. So, given whatever fraction of a Twitter following is actually in LA that would have actually seen Twitter, that actually goes on Twitter and follows a lawyer on Twitter, is speculative. And that's exactly what he argued. And the court took his argument. And whenever you see the court quoting your argument, you know that the court's like, yes, I'm picking up what you're putting down. I talked about this with Rosengart as well. Rosengart, in his motion that kind of backed out Spears into a corner, lays out for the court, Your Honor, you can do this, you can do this, you can do this. It gives the court the arguments to make the ruling in your favor. And that's what Richards' motion has done here. And the court took those arguments and said, yes, I find Girardi's jury pool contamination argument against Richards' employment improper. It lacks any basis in fact or in law as a ground for reconsideration, and she failed to raise the argument in her opposition to the employment application. Should have raised it in the opposition, not the response. It's inappropriate for her to raise this issue for the first time in the context of the reconsideration motion. Conclusion. This is a Chapter 7 case in which a significant amount of assets may be recoverable for the benefit of the estate's creditors. One of a Chapter 7 trustee's primary and most important duties is to collect funds, which may ultimately be disbursed to creditors. A trustee should not be forced to uselessly waste time and resources arguing about whether or not counsel for the trustee should be disqualified for allegedly having said hurtful things about a person on the internet through social media. People are mean on the internet. Unfortunately, this is what seems to be happening in this case. Girardi goes to great lengths to belabor her allegation that Richards did not fully disclose prior dealings made with inappropriate extrajudicial statements and made inappropriate extrajudicial statements on social media. The media communications of which she complains, however, pose no ethical or legal obstacle to Richards' continued service as the trustee's special litigation counsel. Chapter 7 trustee must not be diverted from her responsibility. And this is the argument that both the trustee and Richards made. Look, this will waste our time. We already have the depositions in the context of bankruptcy scheduled. Some of them have been recently pushed back, but they have been scheduled. He's now going after Bravo. We'll talk about that in just a second. Bravo, or going after information that Bravo has. The ball is already rolling. You want us to stop it, find a new lawyer. This delays it. During that delay, assets can be diverted. During that delay, money can be moved or spent. And what we're not going to do is let more money get spent. The court has absolutely no sympathy over mean tweets at all. Ms. Girardi's complaints notwithstanding, I find no conflicts of interest and consequently no reason to reconsider the employment order. And accordingly, I will enter a separate order denying the motion. denied. And then the court extensively goes through all of the objections. This is to the lawyer's declaration and sustained overrule. Like this is the work. This is the work of a research attorney to the research attorney of the Chapter 7 bankruptcy judge. Thank you for this glorious chart. It has made my law nerd heart happy. It made it so easy to read. Well done. Much appreciated. So this compares the declaration, the objection, the response to the objection, and the ruling for every single thing. Every single thing. Every single thing. Every single thing. Pages and pages. This goes to page 35. We're on page 19. That's how much the court went through this. Material objection and declarations, grounds for objections, every single evidentiary objection made. This took some time, but the court went through and made quite a lot of evidentiary rulings, and most of what Erika and her team sought to bring in, the court yeeted on sustaining all of those. And again, for those of you that don't spend all your time in court or watching court shows, sustained means granted. Overruled means nah. Try again. That's not it. But that's not it, though. So we're going to go to Twitter real quick to pull up this letter that has purportedly been served on Bravo and take a look at what was said by Ron Richards. Ron Richards posted this on his Twitter account, sent to EFT Productions and Bravo Media LLC, saying, "Dear Madams, our office is special counsel to the trustee Eliza Miller for the Girardi and Keys Chapter 7 bankruptcy estate. I would hasten a guess that they're aware. At this point, I would just venture a guess. I am writing to advise you that certain steps need to be taken as soon as possible to ensure that EFT Productions LLC and Bravo Media LLC complies with its legal duty to preserve all information." This is what you call a motion to, say it with me, chat. Say it with me, chat. A motion to not delete your shit. That's what this is. This is a preservation notice, a non-spoilation motion, as I have heard it called. Don't delete your shit. With its legal duty to preserve all information that may be discoverable should this matter go forward to litigation. Namely, this company we believe produces or is involved in the distribution of the Bravo show Real Housewives of Beverly Hills. We are primarily concerned with the unaired footage of the show relating to Erika and Tom Girardi. If you believe there is an additional company who is in custody of this footage, please provide and we will send them the same letter. That means another distribution company, production company, editor, whatever. In particular, the company and your employees are obligated to take all reasonable steps to preserve all information, namely unaired footage, including all paper copies of documents and electronically stored information that is or may reasonably be considered relevant to the administration of the estate and or our investigation. That's real broad. Most of these are real broad because it's like anything may be reasonably relevant. You can fight over whether we get it later. You have to preserve it. Later, we will fight over what gets turned over to us. But for now, don't delete your shit. And they're supposed to be broad. You don't delete anything. And then we fight over what gets turned over in discovery. And then let's see, it looks like there's a second part to this. Oh, it's just a signature. All right. And then it's signed. So John says, I find it funny that Richard still uses a P.O. box address instead of a physical address. My guess, he works from home and doesn't have a real office. There are some courts that will not allow you as a lawyer to not have a physical address in motions that are filed with the court. So yes, it's interesting to me as well. That doesn't seem to have been a problem, but yes, it's interesting to me as well. So I think it's funny that you notice that. I always notice that. Amanda says, anyone else think it says bogus declaration and bogus response? Yeah, Borges. So Yep. That is what it is. The preservation notice has been sent. This is what the don't delete your shit is about. We talk about this a lot. It's litigation is coming. Don't delete anything because Erika has a right to trial in the bankruptcy court with regard to any links to this $20 million that may or may not have been loaned to her company from Tom's law firm. And if it goes to trial, anything on the show could be helpful. So that is covering all of the stuff. That is covering, well, almost everything. I'm gonna have to take Austin McBroom off of my thumbnail because sorry, McBroom, we didn't get to you. We kind of did. We kind of talked to it, but we didn't get to it. And we're an hour and 54 minutes in. McBroom is going to get bumped to Tuesday because we spent so much time talking about H3. So let's get to questions. I have questions. You have questions. We have questions. I'm sure I've missed some super chats. I appreciate all of you. This is just like, what? It's so much stuff. It's so much stuff. So is Dave still in the chat? Hi, Dave. It's a lot of stuff. It's a lot of stuff. And look, I just want to bring up the point. We saw people on social media losing their mind about stuff Saltsy had tweeted when the Tati Westbrook defamation lawsuit was going on in Washington. Look back in your mind at the things Saltz tweeted versus the things Ron Richards has tweeted. Because Ron Richards has directly addressed, I'm not saying talked to, but directly addressed Erika, her behavior, things she has said, and stuff that's going on. Where Saltz was asking questions, being like, is this true? Was this said? Have you seen this? Do you have evidence? And they found no ethical issues with what Ron Richards did and no restraint on what Ron Richards did. So that's why you can see when I was giggling at somebody going, oh, this is an ethical violation for Saltz and his tweets and whatever. It's like, no, it's not. So now we have a compare and contrast of two different Kates where lawyers' behavior on Twitter has been brought before the court. And both times it's been like, no, they can do what they did. This isn't a problem. So now we're going to get to super chats. And I'm going to scroll through and then get to questions real quick because I know I missed some. The back end of YouTube's being really weird. But the mods have been amazing in taking down all of the super chats. So huge thanks to the mods with that, because it really is weird that that the back end of YouTube isn't allowing that. I need to reach out and ask them why that's happening, because it's just so strange. Let's see if it's better tonight. Let's see. Sure isn't. Sure is not. Sure is not. We have infinite scroll, so I will do my best. But thank you, Allie, for taking all those down. I really, really appreciate it. I like bringing them up as much as I can so that you guys can screenshot it and I can say, thank you. Thank you. Thank you. I appreciate it. We're going back in time. Can the lawyers subpoena the ghostwriter of Erika's book for anything she said about her relationship to Tom and their finances? I'll have to think on that one. I mean, you can subpoena anything. Whether it will survive the evidentiary objections is different. But yes, to say, hey, let's get all of the notes or the interviews if they're recorded, which if they were audio recorded, they might try to get to. There could be objections, obviously, about that it was not meant for, these purposes, but they are statements made. So possible that they could try to subpoena that, and then there would be objections as to whether it comes back. Ashley Vincent, you're 100,000,000,000% correct. This is an entire memo of per my last email. What the fuck I already said was this. Let me spell it out for you. But it's also protecting the record, and I appreciate the judge being so thorough, because I'm sure Erika will appeal depending on what happens down the road. Arbro, thank you so much. Love your videos, Emily. It really helps me get through hard times, and I hope to be as inspirational one day. Thank you. P.S. Suggestion for the future: include Glory album photoshopped for a new thumbnail variety. I will absolutely, absolutely consider it. I have been using the same Britney pictures just out of sheer laziness. Let's be totally honest. Sheer laziness. Sheer laziness of me making my thumbnails. I know Mr. Beast is like thumbnails 100%. And I'm like, look, man, we got to get to the talking about the lawsuits. I spent a lot of time pulling documents, reading documents, and what have you. Not as much time on the thumbnails. Emily, you are in your element with commentary. We all appreciate you very much. Thank you. This is my favorite thing to do. I love it. I love it. Jean S. I'm sorry. I'm sorry that I've started using yeet so much. It is a slang term popular with like 12 and 13-year-olds and gamers. My son said it like 3 times and I grabbed onto it. So yeet, yeeted, yoted, yeet thyself, yote thyself, depending on the text, the context. Yeah. And I embraced it because it works so well. It works so well to say yeeted instead of denied. I love it. So now I am holding on to slang that has moved past me. It's like continuing to say on fleek. The slang has moved past. I have not, which is, a 40-year-old mom of me. Jessica said, hope you had a great vacation. I also took the first week of August off and it was awesome. Caffeine, whiskey, catnip tip. Thank you so much, Jessica. I know I got back and YouTube was like, your views are down because you haven't posted. I was like, thanks, YouTube. Appreciate the comments. Thanks for keeping it real with me, YouTube. I appreciate it. But it is what it is. And it's hard as a creator not to get looped into that, like, have to always post cycle and to take the downtime when it's needed. Shelby said, thank you, Emily, for all you do. Everyone do the YouTube things. Thank you, Shelby. They should. Miss VKC. Yes, the mods are epic. They are. And I appreciate them so very much. It is one of the things that helps our community be our community. Donna, good to see you. Even on cases I don't care much about, I always learn so much from you. I love being a law nerd. Thank you, Donna. We try to keep it fun and we try to talk about the sassy side of lawsuits. I mean, at least they're fun. At least none of them quoted George Orwell today. So I mean, that was good. JC says, sounds like that Triller has figured out that it's cheaper to file frivolous lawsuits against popular YouTubers to get their name into people's mouths than conduct a halfway decent actual marketing campaign. I mean, that's definitely a perspective on it. Maybe lawyers or these lawyers were less expensive than a marketing agency. Perhaps. Andrea Krebs. I think we'll have to do a poll at some point about what the worst things we've seen are. They might both come from Triller. And maybe a motion to dismiss with a murderous conspiracy, because that was a word salad. Twilt Stripes, I wouldn't necessarily check the reviews for a social media app. I would use it or I wouldn't, I think. And I think a lot of people go that way. I check the reviews on apps, especially when it comes to age appropriateness. But when I use something, I normally don't look at the reviews until I have a bad experience. And I'm like, does everybody have this issue with this app? And then I go check the reviews and go, oh yeah, they did. Montana says, to keep the paw nerds off electronic equipment, try citrus oils or oregano oils. Works on my brat cat. That is a very good idea. The cat yesterday was so. Our word for tonight is colonoscopy. I mean, once you get into your late 30s, early 40s, depending on your family history, it's always a good time to have a colonoscopy. It's necessary medical procedure, but it's one of the ones that gets made fun of. My husband was a prostodontist, and there were, a maxillofacial prostodontist, but he's not watching, so he won't know I dropped one of his honorific titles. Well, it's actually a specifier, but either way, prostodontist, people would get very confused about which end of the body he worked on, because prostodontists deal with this and proctologists with the other. And he would occasionally say wrong hole if he was being cheeky. Motion to rename the Triller lawsuit, but mom, he started it. It really is. But mom, H3 started it. But mom, H3's picking on me on H3's picking on me on Reddit. And it's not even H3, it's a foot soldiers. Talking to spirits and laughing with ghosts. Thank you so much for the super chat. Hands down, best review ever. Go Ethan. It was pretty funny. It was pretty funny. I mean, lawyers spend a lot of money to go to law school, and that's the complaint. Elaine, random love your nails. Thank you so much. I think they're fun. These purple ones have like specks in them. They're almost galaxy-y with like little glitter. I love a glittery nail. I love a glittery nail so much. Belly, sorry, misspoke earlier. It was Michael Kors, not Nike. I'm sure you're addressing the chat. Thank you so much. We are going to have to get down into the rest of the questions and then do a little COPO soon. Talking to spirits, laughing with ghosts while I'm behind. Leave. Let me have a drink, troll. Someone is money hungry in this lawsuit. Just give an honest review, people. Okay, Old Smoky, owner, neighbor, hand me the moonshine. Were you on my stream yesterday when I was extolling the virtues of Old Smoky root beer whiskey? Because I love me some Old Smoky. I do. So that we were literally talking about Old Smoky on stream yesterday. Kelly said, here's hoping Mike will air the inevitable fight between Triller and Ethan, hosted by social clubs. I mean, these events are just going to keep spawning lawsuits. I don't necessarily want it to be content, but it is. But it's so entertaining. Austinite said, can the Duggars keep the government CPS from doing welfare, criminal investigations, checks on Josh's kids? Professional opinion, can Josh get off recent Lawnard? I think that Josh Duggar has an uphill battle and they need to attack the evidence. That is their defense, that the evidence was improperly gathered. I listened in to the entire 5-hour detention hearing. The government has a substantial amount of evidence and did a very good job tying that evidence back to Josh Duggar. And it's going to be very, very, very tough unless there are major flaws in how the evidence was collected. And that's what his legal team will do. The government can't keep another government agency from doing their job in this. There would be no reason that the federal prosecutors would or could do that unless there was some kind of a specific order, but I don't know why there would be and can't think of a situation when there would be. Belly said, speaking of Nike, did you see they started a lawsuit on New Balance? I see that you corrected that later. Thank you. I did not. I do follow the fashion law pretty closely on Twitter and on their blog, and they do a great job of breaking down the clothing world of lawsuits because we cover so many different areas, but there are also a lot of niche things like that cover just one area. Like the fashion law covers a lot of counterfeiting and fashion and high fashion and really narrows down to just that area. So there's a lot of stuff. Skycaster, glad to see you back. I missed Friday lives. I start law school on Monday and just finished a week-long orientation. Any advice for an overwhelmed 1L? Yes. I love that your icon, your profile pic is your Pokemon Go avatar. You're going to be fine. You're clearly a balanced and intelligent individual, but set boundaries, get sleep. Don't let exercise go out the window because it will help clear your mind. When you are tired, you cannot learn anymore. It's when you need to stop and go to bed. Drink at least as much water as you drink alcohol. It's okay if you don't drink as much as your class. Look, law students drink a lot. It's okay to opt out of that. I opted out a lot of that because it just didn't work well for me and for my brain. You can always make up for it later. But don't let all your good self-care habits go out the window. Law school is the time to implement eating well and taking care of yourself and sleeping well. It's how your brain works the best. And what you need to do is make sure your brain is working its best. That is exactly what is most important. So I think we've gotten to almost everything. Did you find out if Dad Spears was paid? We got to that one. So I have caught up. We're going to go down and answer a few questions and then COPO. Thank you guys. I do try to get to the super chats as much as I can. We may get to a point on stream where I can't get to all of them. And I appreciate you and your support of the channel, even if we don't get to all of them. Thank you, Matt Bond, listening while playing Eevee Community Day. Is it going well for you? Let me know. I can't wait for Community Day to start tomorrow. I have quite a lot of shiny Eevee though. It would be nice to get some with better IVs so I can make them into Sylveons and Umbreons because I love them. So, okay, you guys are chatting with yourselves, which is fantastic. Thank you for the round of applause for the judge. Bankruptcy trustee probably got a lot of threats and potentially get a lot of mail from creditors. I imagine a PO box is smart. That the PO box is for Richards, and you definitely are supposed to, in California at least, put a physical address on your filings. It is what it is. But I think he's the only law firm I've seen put a PO box and not put a physical office location, but it's why a lot of law firms will have someone in front reception so they know. My son is an entertainment attorney and he hates it. Well, Lillian, make sure he checks out the Triller lawsuit. And if you want to DM me, I'll send you the lawsuit. So he can at least have a giggle and know that he is doing better than others in this profession. But yes, a lot of attorneys hate their life. That's just facts. Look, other attorneys can be miserable to work with, and you can get a lot of really contentious back and forth, and it can just make your life miserable. And then you just do that every single day. And then you have clients that are like, why didn't this happen? It's like, because the judge didn't do it. They should have, but they didn't. I can't control that. Why didn't the jury do this? Because they didn't. I can't control that. So it binged while we were on stream. We're going to come back to super chats. It binged. You guys, you saw it. It binged. It binged while we were on stream. It's been a while since it's binged while we were on stream. But it binged while we were on stream. Do I not have my it binged clip loaded? I don't. How did it get out of my StreamYard? I'm sorry, y'all. I don't have my it binged. I'm going to have to put it back in. I don't know what happened. It binged. Move your head. Yay. Thanks, everybody. Thanks for subscribing. You made it bing. We're getting really close to 150K. We're going to have to figure it out. We're going to have to figure out what to do at 150K. All right. Elizabeth said, tried to upgrade my subscription. Steps for Google don't work. Are your 2 top tiers closed? Yes. Longtime member, want to give more support. Elizabeth, great question. I have been owing the members a video to explain that we are going to be moving the top tiers over to Patreon because there are some opportunities for more exclusive content. I'm not supposed to tell you this yet. Look, there's only 3,000 of us in here. We're going to have a members only podcast over there. It's called I Have Thoughts. I'm very excited about it. So there will be information coming that is launching in September. I'm very excited. So yes, I appreciate the more support. There will be ways. The Law Nerd level is where we want to be, and the video will be up for members. So for sure. OX Glitter Diva XO, greetings from Ulysses, Texas. May I suggest a drink? Sure. Bailey's Irish Cream, love it. And a couple of shots of butterscotch schnapps. Oh, that sounds amazing. I don't even have butterscotch schnapps, but that sounds very wintry. I love Bailey's. So I will definitely try that. That sounds delicious. I need to screenshot that. I need to screenshot it so I don't forget. We just did it. Tried to get root beer whiskey today. Manager is ordering it for me. Need it after a long day working at the hospital. Mara, let me know or tag me on social when you try it. I'm dying to know what you think. I freaking love it. It tastes like the hard root beer barrel candies to me. It's got a little root beer spice and I love it. Question, can we get confetti when Britney is finally free? I'll confetti the office when Britney's free. I will absolutely bring one of those obnoxious confetti cannons into the office. I absolutely will. We will absolutely confetti. Petition for an it binged emoji. Petition granted. Someone write it down and remind me. Question, is the insurance for lawsuits like doctors have based on like business insurance? What's Alika? I think you're asking about malpractice insurance, and California does not always require attorneys to carry malpractice insurance. It requires attorneys to let their clients know if they do not carry malpractice insurance, but it does not require them to carry malpractice insurance. So yeah, I know I owe you guys an it binged clip. I'm sorry. I'm sorry. Professionals here. I don't know how it got out of my thing. I I will find it for you while we're doing court of opinion, and we'll do a late it banged. We'll do a late it banged. I feel like somebody probably just sent me the link in Slack because I heard it. So, um, I will find it. It's in my, let me grab it real quick. I will grab it and download it, and then we're gonna get the mother like, don't 2 hours and 15 minutes in, and then we're gonna do court of public opinion. And while we do court of public opinion, I will play a late it banged for all of us. Question: would you hire your 13-year-old to learn to create thumbnails? Yes. Yes, I will. Once I have some kind of a process for that, I absolutely will. I'm still kind of finding where I'm going with my thumbnails. It's still a process for me settling on a like, this is how I want them to look. So once I settle in on that, yes, I will absolutely put him to work even more because there is definitely stuff that he helps me with. Did I lose? No, here it is. All right. I was like, where did I put it? How did it get out of StreamYard? We're going to put it right back into StreamYard right now. I can't believe, hopefully it doesn't crash the stream with me trying to upload it back in. Pam Marshall, Secret Squirrel member stuff. Yes, we will be talking about it some more for sure. Question, Ali C. I'm not American. Sorry. No, don't ever apologize. Don't ever apologize for asking the questions. It's okay to not know this stuff. Americans don't know this stuff either. We just don't know. Don't assume that we know. We don't know. Not everybody knows. So no apologizing for not knowing. Always just ask the question. What jurisdiction does the FBI have? When does a case leave the police and go to be investigated by the FBI? And is that good or bad? That's a lot of questions. The FBI has a very broad federal jurisdiction because they're a federal agency. There are different types of crimes that they can investigate that they have jurisdiction on. They can really easily investigate stuff that's interstate. They can investigate stuff that happens online. The FBI generally has more resources than most police departments, particularly in smaller states. Some police departments in very large metropolitan areas have great resources, but the FBI, depending on the branch, tends to have more resources than a lot of local police. And they have resources, particularly when it comes to cyber crimes, where they can send stuff out and have more access to other agencies. So the FBI as a federal agency has very broad jurisdiction over not just criminal investigations. After looking at your polish, I went shopping at Holo Taco. They need to give you free polish. Holo Taco sent me an amazing gift. I haven't shared it yet on, they did give me free polish. They sent me an amazing package that I will be sharing on social media of their new release. It's epic. The box is epic. Christine does a great job. She sent me a wonderful gift, so I will. The big screen gives me life. Well, thank you. We get to do that right now. Once Britney is free, I'm having a caramel frappuccino to celebrate. I mean, go all out. Go all out. Go all out. It's time. And then we're getting to court of public opinion, I promise. Oh, it binged! Move your head! Ah! All right. It's time to get to court of public opinion. It's one of my favorite things to do. Oh, thank you, Tech, for sending me the link. We got it. Court of public opinion is one of my favorite things. It's where we get to talk about things that are kind of inconsequential and agree to disagree, or agree that we're all right and the rest of the world is wrong. And then I put the polls up on Twitter and on Instagram. So take a moment to do the YouTube-y things, the likey, subscribe-y things. And if you want to follow me on social to participate in the polls there, you can. And I will also put a poll up on the channel tab. And now that we have polls in here, we're going to kind of craft the question, because we need to talk about this week's court of public opinion. Like we need to. This has been following me around the internet for like 2 weeks. Look, we talk about showering a lot on the court of public opinion, like we just do. That just happens. We talked about, do you shower in the morning? Do you shower in the evening? We talked about the time of day to shower. You know what we didn't talk about? We didn't talk about how frequently you shower. And apparently, this is a big fucking deal. And I started talking to my husband about it and talking about my opinions on it. And he was like, wait, what? And I was like, wait, what? And so I think that this started with Mila Kunis and Ashton Kutcher on the Armchair Expert podcast of Dax Shepard, talking about the fact that they don't bathe or they don't shower literally every single day. And that when they do shower, they don't wash like everything with soap. They don't soap like every single thing. I think what Mila Kunis said was like slits and tits is what got soaped. I think this ended up on Phil DeFranco this week. This is everywhere, and other celebrities are getting asked to comment on it. The Rock has said he showers like 3 times a day. Okay. He's like, no, there's like different kinds of showers. There's like 3. And yes, we know that people have different kinds of showers. There's the like hair wash shower. There's the deep condition face mask, shave all the things shower. There are different levels of showers. And I think this is seasonal too, because The Rock's like, well, 3 times a day. And if you live somewhere tropical, I mean, if you walk outside into 85% humidity, you're going to want to shower again at the end of the night. We get it. But the not showering every single day seemed to raise the ire of people. And it's just wild. Yes, tits and bits. And then Ashton said slits. So, like, I really don't soap and lather all of the things that don't need it unless I've been like out in the wilderness, you know? So, Jennifer Park said, my mom always said face and hands, feet and seat. I love that. People are riled up. Like, people are riled up about people not showering every day. Like, people are very, very upset that people do not shower every day, but people don't shower every day. And that's okay to not shower every day. Some people shower twice a day. I feel uncomfortable all day if I don't shower. And see, I do like a bath at night before I get into bed, but it's also the middle of summer in Middle Tennessee and it's hot AF all day. And I don't want to get into bed feeling still kind of sweaty because I don't like it at all. So Emmy says sweat is water soluble. You don't need to use soap for sweat. I mean, and this is the thing. This has created a whole thing. The Rock says he showers 3 times a day. And yes, it involves working out for sure. Like a quick cold wake up shower, a post-workout shower, and a before bed shower. But also they asked, oh gosh, hold on. They asked, well, they didn't ask. Cardi B weighed in on Twitter about this. This made it everywhere. This became mainstream. This is a slow news week. Cardi B is confused by celebs who don't shower regularly. It's giving itchy. What's up with people saying they don't shower? It's giving itchy is what she said on Twitter, because there were other celebrities like Jake Gyllenhaal that were like, no, I don't shower a lot. Jake Gyllenhaal says he doesn't find bathing regularly necessary. I want to know the definition of regularly. Are we talking Steve Jobs shower once every like several weeks? Are we talking about not wearing deodorant? Are we talking about showering every couple of days? What is regularly? What does it mean? And why does Vanity Fair give a fuck? More and more, Gyllenhaal says, I find bathing to be less necessary at times. He told Vanity Fair last week while promoting Prada's Ocean fragrance. Is he literally just like taking a cologne bath? Is that part of his ad campaign for Prada? Like, the Prada Ocean fragrance smells so good that I find bathing less necessary. Is this all a marketing campaign for Prada cologne? I have questions. Colleen said, what about water conservation? More of a concern in the West United States, not such a concern in the South and in the middle bits. So where you live, this will vary by region. If I lived in California, I would have, when I lived there, showering 3 times a day would never, ever fly. Showering kind of got planned, and there was definitely water conservation efforts. We had rain barrels, all the things. But living here with the humidity, I can see why people shower more regularly than I showered in California, because you get hot and sweaty and it's humid. So I get it. I get it. It also goes into other celebrities talking about this. Mila Kunis, Ashton Kutcher have shared that they only give baths to their kids as infants when they could see dirt on them. Again, my kids had more sensitive skin and I didn't want their skin to dry out. We did not bathe them every single day. Kunos said, I didn't have hot water growing up as a child, so I didn't shower much anyway. I wash my armpits and my crotch daily and nothing else ever. I've got to borrow Lever 2000 that delivers every time. Oh, that was Kutcher adding that. That's where we get into the pits and bits and slits. Not all celebrities are skipping the soap and water. However, Dwayne The Rock Johnson added that he showers multiple times a day. I am the opposite of not washing themselves. Celeb Jumanji answer tweeted, shower cold when I roll out of bed to get my day rolling, shower warm after my workout before work, shower hot after I get home from work. That's actually a solid plan because the cold shower in the morning is going to wake you up. The warm shower is not going to make you sweaty before you go to bed. And the hot shower at night is going to kind of lower your body temperature so you can go to bed. Jason Momoa said basically, I shower, I'm Aquaman. I'm in the fucking water. Don't worry about it. I'm Hawaiian. We got salt water on me, which is not the same because there's two conversations here. Like there's a soaping conversation and there's like an act of like water over the body. So what is the question here with celebrities not showering? Is it how much do you soap? Like, do you soap all yourself? Or is it like, do you shower daily? What is the question and why is everyone so riled up? Why is everyone so riled up? Angel K, yeah, it is a filthy word in context. It is. It is in context. Amy Yose, shower daily with soap and lather my body. However, I only wash my hair like 2 times a week. Oh yeah, the scalp needs to not be washed all the time, which is actually healthier for your hair, but I've always wondered if the same applies to your body skin. Thoughts? I don't lather full body. I think that's the question. When it comes to showering, do you shower daily or less regularly? And do you soap all the things or just the bits? And I think that's it. That's it. So, you need to shower up and use a washcloth or loofah with soap to clean everywhere. I mean, nope. Totally don't lather my legs unless I'm shaving. Totally don't. Totally don't. My grandma, born in 1906, had what she called a cat bath, using a washcloth to bathe her bits. She also skipped washing her hair by using baby powder and perfume. I mean, and a lot of people do. My dermatologist said use soap only on parts with hair. I mean, okay. Showering is only necessary. Shower every day, soap every day. I don't see why people are so up in arms about other people's bathing habits. Me neither, but it's the internet. And now there's videos of Mila Kunis and Ashton Kutcher like bathing their kids, like, see, we bathe our kids. But again, some kids don't need to shower every single day or bathe every single day. In the summer, in the South, every day. Every day. Hot, sweaty, gross. But in other parts, maybe not. Also, now that I have a 13-year-old, every day. Every day. But as they get older, maybe not. So I think they snuck in. Well, George snuck in quietly and didn't come jumping on the desk because he's George. Hi, George. Yeah, he's like, no, we're giving partial acknowledgement, not full acknowledgement. So we need to put up a poll. I think the question is, do you shower every day? Do you soap all the things? I think there's like multiple questions, but I think that's 2 separate polls because the question here, okay, we're going to stick to the main question about the showering every day. We're not going to get to the soaping because the soaping habits are a completely different court of public opinion question. Maybe we'll get to that next week. We've got to get to the frequency because we asked about bathing and timing of the shower, but we didn't ask about the frequency of the shower. And that seems to be what people are up in arms about. Showering every day, not showering every day, because it started with Jake Gyllenhaal saying, I see bathing being less and less necessary. And what's regularly mean? I don't know. Alexis said, I live in Louisiana. I shower every night or I feel disgusting in bed. Granted, Granted, but I do not scrub heavily, only wash my hair once or twice a week. Right. Dee Dee's like, how do you shower without soap? You just get in. And then there's water. And then you're good. Oh, this page 6 is slowing down my browser and slowing down my stream. Okay, goodbye, page 6. Goodbye. So that's where we're at. The internet is at odds over the bathing habits of celebrities. And I feel like the law nerds are going to save it on here. We're the ones that are going to answer all the questions about the frequency, not the AM, PM of it all, not how often you wash your hair, because hair habits are so much. So we're going to do 2 polls, one about frequency and one about the sudsing habits. Those are our 2 polls. I will put them up on social. On Tuesday, we will rule on court of public opinion with both of those polls. So yeah, we're creating 2 polls. Allie's like, y'all are making me itchy. You and Cardi B are on the same wavelength. She's like, stop it. Soaping is complex, different cleanser for different bits. Soaping is complex. And I think we're getting definitely going to see some variety based on regionality and where people are and how hot, cold, or what have you it is. Naya, I'm so sorry. At 2 hours and 30 minutes, we did not cover the McBrooms in extensive fashion. It got bumped because we covered the H3 stuff much more extensively, and there is so much to cover. So I will be changing the title when we finish stream so that it is accurate. You guys, that's court of public opinion. I'm going to put all the polls up. Let's see what the poll that we've put up now says, and then we're going to roll on out of here. We've got 2 polls that'll be up on social. Do the YouTube-y things, do the likey, subscribe-y things. Follow me on social media if you want to participate in those polls around the internet. And that's it. Titles changed already. Yes, because my mods are amazing. Thank you. I will change my I'll change my thumbnail, and we'll touch on all of the McBroom Doom lawsuits on Tuesday, which I talked about earlier on the stream. We kind of gave a summary of what was going on, but we didn't dive into those. There are 4 that I have pulled up. So we'll dive into each of those documents, because we've got LiveX Live suing Austin McBroom. We've got Simply Greatness suing LiveX Live, and we've got Taylor Holder suing Austin McBroom. We've got James Harden saying that he's suing, and then we've got Austin McBroom seemingly admitting that LiveX Live is not wrong about the numbers, and that kind of undermines his entire lawsuit. There is so much going on, and we'll pull up all of those. So there's a lot. Poll complete. Showers every other day, 37%, daily 32%, when stinky or dirty, 21%, more than once a day, 7%. That is a perfect poll. We will put it up, and we'll ask about soaping habits too. Law nerds, it's been a long stream. I appreciate you. Thank you, Matt Bond. I will take that shiny luck for EV Day, and I will keep you posted on social with that. Law nerds, thanks for being law nerds. May your Wi-Fi be strong. May your families be well. And I will see you in the next one. Thank you for being here. Good night. Connect with me everywhere. I'm at the Emily D. Baker. If you guys want to join the text, just text Emily.com. If you want to join the channel, lawnerdsunite.com. Happy to have you. Support what we do here on the YouTube.